You could just call us back.
All right, if we can please settle so we can take up this matter.
I believe Vice Chair Richards, you were discussing a motion. Do you have a motion on the table?
Well, I'd like to first hear from,
Or for the table?
I wanted to give you all some time to convene, and it sounds like you did a remarkable job of doing that. So if you can maybe elect somebody who can report back to the board.
Yes.
Teamwork.
Thank you. So one thing that we're willing to do, if the board will be amenable to this, is from the federal parties, we'd like to move to adopt the technical testimony and examinations that have been to date by all the permittee parties. In law school was amenable to that. They wanted to stipulate that Angela is not an attorney, but she is an environmental. You've seen her testimony on that. And I think that since there's been some questions about that process, I think Angela could help clarify some things. If you'd like to speak with her, we could make her available just for board questions and nothing else. With that as well, we'd ask you to rest on the testimony of Carolyn Holloway, which is basically the timing for permitting. And the reason to rest on that is her son is disabled and had surgery Wednesday. He has complications and they are still in the hospital. So if we could rest on that testimony, we would appreciate that. And the other parties were amenable to that as well. That would just leave one witness for us to bring present, which is just to kind of wrap up the NTES Sandia Lab relationship and the communications. Is anything else that I missed? Do you guys have anything?
Other than the parties are going to strive to limit their testimony and cross-examination to the extent that we can. I think that it's the consensus, and please anybody correct me if I'm wrong, that the really important thing is having the board be able to examine these witnesses and ask your questions.
Who is that witness between the labs and NTES?
Daniel Sanchez or Danny Sanchez.
Dan.
So yeah, he would be the only witness we'd bring in person. But again, we would like to make Angela available if the board would like to just ask her questions, and just if you could just let us know, we would, figure out when to do that. She was going to be testifying online. There was one other motion on paragraph 8 of the hearing officer's order. It actually provided for 30-minute closings. We'd like to move to 10. And that would be it if those motions are acceptable.
Is the 10-minute closing agreeable by all parties? All right.
Petitioners don't object.
All right. And we will accept that evidence as you stated, Ms. Richards?
Yes, sir.
And I don't expect there's any objection to that.
No, but if you could let us know if you'd like to ask Angela questions, just let us know so we can contact her. She is on East Coast time.
Will do.
Thank you.
The board is in receipt of the testimony.
Mr. Hearing Officer, I just wanted to make clear that although there is a person who would be talking about NTES, that Ms. Richards will be presenting. NTES itself does have 2 witnesses that it will still want to present to the board.
Okay. Okay. You still have the 2.
3.
Yes.
Is that Avery and Shu?
That's correct. And like everybody, we'll try to be quick and summarize testimony so that you can then ask questions.
And hearing officer, just to follow up on that. I'm sorry.
Speak into the microphone.
Is it not on again? Okay. I'm as close as I can get. Just to follow up on that, we will also formally move to adopt NTES's testimony as our own since they're our contractor.
Okay.
And Mr. Hearing Officer, Madam Chair, members of the board, one other thing that may help inform the decision at this point, and we've informed the other parties of this, petitioners would object to cross-examination of Mr. Albrecht on anything other than his resume, which was the only thing we've been provided notice of. Now, that's not to say that we would object to the board asking questions, but we do object to any cross-examination by other parties.
All right. Between now and then, we'll consider limitations on examination of Mr. Albrecht, depending on where we're at.
Sorry, I just want to make sure, Mr. Domenici, have you, do you have any input into this in terms of a way to basically condense the list of your 5? It looks like you've got 5 or 6 witnesses, you said. Can you please respond to that question?
Sure. 3 of those witnesses will be talking primarily about portable sources. 2 of them will be talking about how you need a portable source to keep a modern airport. 1 will be talking about how you need a portable source for these enormous I-25 and I-40 projects, which are on the calendar. So their testimony will be factual and limited in that sense. I have 1 witness from the company Curia, which is a pharmaceutical manufacturer. They just did a $100 million expansion, and they fully expect to need a modification. Under this rule, that would not be allowed. That would be a short testimony. And then I have 2 asphalt plant operators. They both will be short factual testimony about what they've done to acquire their permits and how they operate under those permits. And I will be withdrawing my request that the board counsel testify. I will ask, there was an exhibit attached to that. I'd ask that still remain part of the record. I had listed Sherman McCorkle. I'm withdrawing him. I had listed Jim Garcia, and I'm withdrawing him.
Thank you. I would request that perhaps you, since many of these people are business operators, is there a way that you can maybe consolidate that testimony? It looks like you've got some duplicative testimony. Based on the hearing officer's order, he asked that there not be duplicative testimony from the panel. And this sounds like a panel, so.
Look, the parties with the portable sources will be sitting as a panel, listening to each other, so they should be able to avoid repeating what
Great.
already been said. The Curia is totally unique, so she'll just make her statement and be available for questions if there are any. The 2 asphalt operators will be sitting next to each other. They do have different plants. They were permitted at different time periods, and they're in different locations. So there will be some testimony unique to each of them, but the duplicative part, we won't put on more than once.
Great. Thank you for that consideration. I appreciate it. Okay.
Mr. Hearing Officer, I have Member Lewis and Elaine Semino with their hands raised.
I'm
sorry, who's speaking? Oh, I'm sorry.
It's Anita.
I have Member Lewis and Elaine Semino with their hands raised online.
I'd also like to raise an issue as well.
All right. We'll note that Member Lewis is online. Ms. Semino, we will get to your questions once we get through these preliminary matters. I'm not, I guess Member Lewis, I'm not sure if she has something to say.
This is Member Lewis. I was just actually going to call attention to the fact that Ms. Semino has been entering things into the chat, and I didn't want those to get lost because they're relative to her objections to this process.
Okay, thank you. And we did receive her amended closing statements, just to let Ms. Semino know. Further?
The comment from UNM.
Mr. Hearing Officer, UNM's already reduced the number of witnesses that it intends to present today. There's another witness, Mr. Casey Hall, who's present. We are willing to waive direct testimony so long as the amended direct testimony is admitted into the record. And Mr. Hall, though, we would be happy to present Mr. Hall to the board for any questions that the board might have for Mr. Hall. And then UNM does have 2 technical witnesses that it would be presenting testimony for today. I would ask the board to keep in mind that UNM has submitted an alternative proposal. And so the fact that that is there as well may require some additional time. So we would ask that you keep that in mind as you consider time limitations moving forward. Thank you.
If I may, Vice Chair Richards, so it sounds like we have a panel of 3 witnesses for asphalt companies, a panel of 3 witnesses for UNM, 1 for Sandia and I'm getting everything mixed up, NNSA, 2 for NTSS, and then questions of EHD, and some of them are quite short. Am I getting that right? Okay, I see.
That seems right.
Okay, just for your information.
Thank you. Thanks for tabulating that, Chair Paul. Okay, then this is my motion. Starting with Mr. Domenici, I'd like to request that what time is it now? We've done it.
9:15.
9:15.
Okay, I'd like to request that testimony go through 10:30. So basically, he spent, I believe, more than 4 hours yesterday. And then this morning, to allow that to go through 10:30. I'm going to go ahead and write this as I'm doing it. For UNM, which I believe is the next one, I'd like to request that go from 10:30 to lunch, 12 o'clock. And then recess for lunch. And then after lunch, to go, I need to write these things down. Okay,
Right.
10. Are you writing for me?
Yeah.
Thank you. For NTES, I'd like to request that they go from let's say 10 to 12, so 2
NTS
to
and
3 o'clock.
NNSA?
I'm sorry, what was that, Chair Paul?
NTES and NNSA?
No, I was going to separate them out, but Ms. Richards, do you feel like they need to be separated out?
I think that it would make sense maybe for NTES to go first so we can adopt their testimony. And
Okay,
then we'll bring Mr. Sanchez.
Is,
I really am. It's just not working very well. I apologize.
you just need to pull it up to you.
And we would bring Mr. Sanchez directly afterwards. I'm sorry? I said we would bring Mr. Sanchez directly afterwards. I can't get more than 2 inches from the head of the microphone.
Okay. Okay, so let's go ahead and go with NTES then, from 12 to 2, followed by I'm sorry.
Vice Chair, just to clarify,
Yes.
if we kind of estimate that we're coming back from lunch at 1 o'clock, you're going to give NTES 1 hour?
Oh, I'm sorry. Yeah, 1 to 2 o'clock.
1 to
Thank
2
you.
o'clock.
Or I'm sorry, 1 to 3 o'clock. And then after that, the following party, I would say for an hour or less,
So,
depending on
okay.
what their need is.
Oh.
And then finally, I believe we have, tell me if I'm missing anyone. I didn't sleep very well last night. So then we have Mr. Albrecht, who's available for questioning. And I would say let's limit that to an hour of questioning. I don't imagine there will be more than that. We have Pueblo Isleta, who is offering closing comments. And I think we already mentioned 10-minute rule for closing comments, as well as Ms. Semino. So that is my motion. I have not been writing this down, but maybe you can repeat it, Chair Paul.
I can repeat it. Did the board understand? So your motion is to have the parties represented by Domenici until 10:30, UNM until 12, a recess for lunch for an hour, NTSS from 1 to 3, NNSA after, then
1 to 2 or 1 to 3?
1 to 3, and then 3 to 4 for NNSA, and then Albrecht after that, and then closing after that with a public comment section at 5:30. And 8 p.m. is the cutoff for today. Did I get your motion
Yes,
right?
that's absolutely
Great.
wonderful.
Is there a second
Thank
to
you.
that motion?
Did anybody second? I didn't hear.
No. But I'm still looking at board members to see if there is a second. Is there any discussion around that motion?
Could you clarify, is the goal to essentially finish a core part of this process by the end of the day today?
Yes. I believe so. You can
May
ask.
I answer that?
Sure.
I think the goal, I actually, when you're online, you get a very different perspective. And I saw, Ms. Richards, that you had been sort of online, hanging out, waiting. And then we had public comment. So the goal here is to afford due process for everybody, all of the parties. And so ultimately, that is what my objective is with this, as well as recognizing that all of us have lives that we must live. Several of our board members have taken vacation time. So that's the objective.
Is there any further
And
discussion?
This
on
is,
the motion?
yes, this is Member Lewis.
Yeah.
Online.
Member Lewis.
So can you, can you please also just take this to the 8 o'clock closure time? Are you anticipating that the entire deliberation then will be happening from 6:30 to 8 tonight?
No, there was no discussion of when the deliberation was in that motion. Does that answer your
Okay.
question?
That, I just wanted clarity on that. Yeah.
Okay. Is there any?
Can I ask a
Please, go
question
ahead.
just related to deliberation, just procedurally, and maybe this is a question for our council, because this meeting was only noticed through today. If we're not doing deliberation today, can you just talk about how we would do that? Are we going to set up a special meeting? I think we all realize we probably need a couple days for deliberation. So how would that work?
The notice was until these proceedings ended. It was for 5 days or until these proceedings ended. I think it could then be recessed for deliberations, but I would like to provide, if the deliberations, this is just hypothetically, an example and a suggestion, that if deliberations were to be online after the special board meeting that is already noticed, we could notice a subsequent, you could have the closed special meeting that is now set for Monday, and then you could do another special notice or special meeting notice for deliberations. I would be more comfortable giving special notice for deliberations so that they can be on, your deliberations can be transparent as possible. The problem is I mean, this is kind of splitting hairs. The rulemaking requires presence of the majority of the board. But deliberations, the notice said deliberations could take place at a subsequent meeting. And so I would be more comfortable noticing a subsequent meeting, which would be a special meeting, at a special virtual meeting at which your deliberations could take place. And I think with that, we would satisfy the Open Meetings Act.
I also have a question for you. Is there any issue with, just because I'm concerned with getting to be able to ask questions of each party, even though I really appreciate how the parties are working together. Is there any issue in the process with not limiting the testimony to today, but still taking some closing and testimony over Zoom in a special meeting?
If you, at the end of the day, not adjourn, if you, at the end of the day, recess until Monday, the problem with doing that online is the rules require that a majority of the board be present for the rule-making process. And so it would be better if you were to finish the rule-making process today, adjourn it today, and then have a special meeting for your deliberations. Because taking evidence and having this totally online would violate the rule that requires the board to have a majority of members present.
Can I just
Thank you
ask
for
a
that.
follow-up?
Please, Member Kalman.
So just to make sure I understand, you're saying that if we did all of our deliberations online at a special meeting, we wouldn't be able to ask any additional questions?
That's correct. Once the evidence, once this rulemaking proceeding is adjourned, the rulemaking proceeding being handled by Judge Sanchez, the notice said that the board deliberations would take place at the close of the evidence or at a subsequent meeting. So then you would have to notice, and it's 72 hours for a special meeting. And since you already have a special meeting scheduled at, I believe it's 9 on Monday, we could do a notice today for a special meeting after that. And your deliberations could take place online.
Madam Chair, members of the board, if I could just offer a suggestion, would it be to put in the mix, and that's to leave the record open until your notice meeting on Monday in order for the parties to submit written closing statements.
We had actually talked about that and giving all parties the deadline of tomorrow, 5 or 6 o'clock. I know tomorrow's Saturday, but if you email those to the group that you've seen, those closing arguments would get to the board members.
Your Honor, I would object to leaving the record open. I think that with regard to Ms. Cedillo Lopez's discussion, leaving the record open is akin to leaving the rulemaking open, and it would need to conclude to comply with the Open Meeting Act. So I do think it has to conclude at 8 o'clock tonight. I concur with that assessment.
And if I
Are you
may,
saying, does that include the closing statements?
If it's part of the record, it's part of the rulemaking.
if I may, Mr. Hearing Officer, I disagree completely with Ms. Richards' assessment. It's commonplace for boards and commissions to leave the record open after the live hearing in order for closing submissions.
I have a tendency to agree. I think closing argument can be submitted. It's not evidence, it's just closing argument and surmising or summarizing the evidence that's been received at the, I don't want to say at the close of the case, but at recess.
And Mr. Hearing Officer, just my comment, I think that this appears to be a rush to completion, and I'm not sure that's, it's really the board's decision, but I don't think you end up getting a full picture of all of the proposals on the table by doing that. Plus, you know, that there were no limitations or similar limitations on petitioner's case. So I think limiting the opposition to what you're talking about, I think unfairly limits the opposition to their ability, and there are pending proposals from others other than petitioners. So we would state our objection to proceeding in that fashion, and we think it should proceed in the normal time frame that we've done the last 4 days on. Granted, it's taxing on folks, but I think limiting parts of the case artificially is only going to make specific problems more apparent in terms of if it's the board's wish that this rulemaking withstand scrutiny. So that would be our proposal.
I also have a problem with the motion, and there's some constitutional problems if one side gets to present everything and then the other side is truncated because of a time limit. So unless we have express consent from each party to do this, I have a big problem with it.
Vice Chair Richards, did you want to continue? Go ahead.
Oh, let me ask you then, Member Armijo, if you have an alternative. My concern again is making sure that everybody has due process, that all of the parties have due process, recognizing also that this hearing cannot go on in perpetuity, and that there has been some duplicative and repetitive testimony. So do you have any recommendations? You've got a legal background, Member Armijo. I'm willing to listen to those.
The only recommendation I have, like I say, is if every party agrees to this, fine. If one party does not agree to this, I think we're leaving ourselves wide open for an appeal and probably a loss.
So I'm going to offer a suggestion to the board. First, if we could get any objections to that, those time limits in a very general sense, and think not to the exact number, if that's appropriate. Are there any objections from any party to general time limits?
Madam Chair, we object.
Okay.
Hold on.
I object, Mr. Hearing Officer. Part of my time's being used up right now, just for example.
We understand. I'm trying to wrap this up.
I would also, just the other piece I object to is not having more time to do a closing written closing. I think you're not going to get anywhere near the quality that really the amount of evidence deserves.
Can I ask another question? I'm
Yes,
sorry, it's
Member
another
Kalman.
board council question. So if we don't adopt Member Richards's motion and we don't finish everyone's testimony today, then what do you see as the next steps?
You could continue the hearing or recess the hearing today and continue it. The problem is you will have to find a location. Because I believe we only have this facility until 8 tonight. So, and I could work on that. Would need to find a location and continue it. Whatever time you decide. I have not gotten an answer from the courts about the the temporary restraining order, and in absence of a decision from the courts, I think you only have until the end of day, well, midnight, I guess, on Monday to complete this. I'm hoping to get an answer from the courts, but I don't know.
I think that as Mr. Domenici said, we're starting to eat into any time. So what I'd like to do is hear your motion again, Vice Chair Richards, and see if there is a second for it.
Thank you. So the motion is, and I'll extend timelines in respect to Mr. Domenici's dilemma here because we've taken some of his time. Mr. Domenici, and at 11 o'clock, UNM go from 11 o'clock to 12:30, recess for lunch at 12:30. NTES go from 12:30 to 3:30. I'm writing this down
Is it 1 hour that you're giving them?
I had 2 hours,
Okay,
but
2
I
hours.
think I was including NSA also. Oh, I skipped okay, 1:30 to 3:30 for NTES. NSA 3:30 to 4:30. Mr. Albrecht,
Do you have that reversed? I think it's NTES that has the 2 hour and Ms. Richards' client 1 hour.
I probably, okay, so let me redo this. I'm sorry. I did not sleep very well.
If you can just let me know how much time is allocated.
Okay,
If you can
thank
just let
you.
me know how much time is allocated for each party,
Okay.
because the time's going to start moving once we put Ms. Semino on.
Mm.
So I need to
Okay,
know.
yes,
I'm
that's a
gonna-
great idea.
I'm
Okay,
going to
so,
need to know how much time is allocated for each of these remaining parties and how we're going to allocate direct examination and cross-examination between the following 3 parties or so that follow. So
okay.
that
Mr. Hearing
might-
Officer, let me go
might
ahead
be a
and
challenge.
work on that. Okay. My motion is to, because Mr. Domenici has spent quite a bit of time yesterday on the panel of 3. In fact, it was over 4 hours, I believe. I'm asking for 1 hour for Mr. Domenici. Again, the purpose of this is to provide due process for everybody and allow the board members to get back to their lives. Domenici is 1 hour. UNM is 2 hours. NTES I had for 1 hour or 2 hours. 2, thank you. NSA I had for 1 hour. And then Mr. Albrecht I had for 1 hour. Ms. Semino I have for closing statements as well as Pueblo of Isleta. That is my motion.
Thank you. Is there a second to Vice Chair Richards' motion? Or online? I think our Member Lewis, are you frozen?
She's having some network problems.
I'm not hearing a second, but I also can't hear Member Lewis. Nope, she's there.
I'm here.
All right. Are you, I'm just making sure you're following the proceeding and you heard
Yeah,
the motion
I
on the
am.
table. Okay.
Yes. Thank you.
Okay, I would say that fails. So if somebody else wants to make a motion,
Yeah, I think we should continue on. Again, we still have that option to recess and potentially have a new location to do deliberations and continue on our parties. So let's
May I
let's
ask
get
for
going.
a decision on my earlier motion, at least as respect to the federal parties? I had moved that we would like to adopt the technical testimony of the permittee parties.
And we adopted that
Okay.
and we love your approach.
Thank you. I just wanted to make sure on the record it was all clear. And the board will let us know if they'd like to have Angela available for
And
exam.
as you all can imagine, it would have been a struggle for me to try to manage Mr. Domenici's, for example, witnesses within an hour, considering board questions, follow-up questions from petitioners or otherwise. That would have been impossible to get this thing done, to get that presentation done within 1 hour. I mean, you've kind of seen what what I've had to deal with the past 4 days.
Mr. Hearing Officer,
Yes.
may I just interject? And I apologize for coming in a little bit late this morning, but
No problem.
if it's helpful at all, I do believe that the 2 hours mentioned in Ms. Richards' motion would be certainly adequate for the direct part of Tessa's testimony. And I'm thinking probably also for cross, but I of course can't control that. I would like to, however, bring up a different matter. Sorry. Which is that we all need to silence our phones. I would like to, I've been, as many of the lawyers in the room have been involved with many different administrative proceedings, rulemakings and adjudications before boards like this one. And it is, although perhaps not uniform, it is fairly standard that parties be allowed to review transcripts of the proceeding and after it has been filed, following the conclusion of the open hearing, and on the basis of that transcript, develop closing written arguments, findings of facts, and conclusions of law to be presented so that the board can have some reasonable context for the summation of that party's views and help in guidance in thinking about findings of facts and conclusions of law. I think that's particularly important. That standard practice is particularly important in this case because, and I don't need to belabor it, but the various versions and the on-the-fly proposed changes and redlining that we've seen in the course of this proceeding. So I guess if you'd like it in the form of a motion, I move that whenever we conclude the hearing portion of this proceeding, that we also allow time for the filing of the transcript of the proceedings. We've paid for the court reporter to take this down, and there's usefulness in having that. And then a period of time, 20, 30 days, whatever, to submit closing written arguments and propose findings of facts and conclusions of law for the board's consideration. Thank you.
Mr. Hearing Officer, I just wanted to let you know that I believe in the hearing order that we did as a board, we talked about deciding, having the ability to decide whether or not we would hear closing arguments. Board counsel, can you please refresh my memory on that?
I'm sorry.
Yeah, I know you've got a lot going on. I was just telling Mr. Hearing Officer, I'm sorry, what I forget your name.
Mr.
Boutier had just made a motion regarding keeping the record open so that they could provide have opportunity to review the transcript from this hearing, formulate closing statements and something else. But I recall that in our order, we reserved the right of the board to decide on whether or not they were going to hear closing statements. Is that accurate?
That's correct.
Okay. So what I would recommend is, can you hold that motion till maybe towards the end of the day so we could decide? I'm concerned about taking more time from again, I'm concerned about parties being able to testify.
Absolutely. It's,
Okay.
Mr. Hearing Officer, Madam Chair, members of the board, it's at your discretion. I'm happy to defer it until the end of this proceeding.
Thank you so much. I really appreciate that.
And Madam
you're
Chair,
right.
I hate to take one more second, but can
Member
we
Lewis?
just also clarify? Can we also please clarify whether Mr. Rose still holds his objection? Just for the record.
The motion didn't pass, so the objection was to the motion, so he doesn't, I assume, and he's nodding.
Okay.
Great. I think we can proceed now, Mr. Hearing Officer.
All right, we'll continue where we left off, and I believe Ms. Semino has been patiently waiting so she can ask her questions of the panel. Ms. Semino, can you hear us okay?
Yes, I can hear you. Can you hear me?
Yes, we can hear you, we can see you. You can ask questions of any of the three panel members at this time.
Okay, thank you. I just want to introduce myself as a pro se party. I'm retired adjunct faculty from UNM, and I direct grassroots community environmental justice advocacy group. I live in a disproportionately impacted, overburdened neighborhood. I'm working as part of the early adopter program for NASA and working with the HAQUEST, which is a health and air quality applied science team, along with the USGS. We have various group members throughout the community that is working on our project. And one of them is a special project with NASA for remote satellite sensing, along with the USGS, HAQUEST, and several universities across the nation, including the faculty and students from UNM. We are conducting community-based participatory research, and our work is calibrated, validated, modeled, and analyzed by the top scientists in this country, and they're ready to stand with us. My questions are as follows for the panelists. I pose 3 questions in the first, and please, those who are the experts in these areas, please respond, because yesterday was a long day. And has any of the panelists used remote satellite sensing or modeling and ground-based measurement of data collection for emissions? I'm going to ask all 3 questions and you pick one. Who on this panel has experience on collecting and modeling data that uses satellite data? And who has used the data from community-based participatory research in evaluating air emissions? That's my first question. If you could please respond.
Thank you for the question. I think those were 2 questions, so I'll answer both. The first one around the satellite data, personally, no. I do not have any experience with using satellite data. The second question about using community-based participatory research to inform decisions, yes. I did that quite often when I was at the state as a state toxicologist. I also oversaw an oil and gas health information and response program where we had a hotline. We would also provide actually air sampling kind of kits or for community members to be able to collect their own data when they felt they were having self-reported symptoms. And we would use that information along with other data that we would collect in making conclusions.
Does any of the other panelists have any background in a remote satellite sensing?
Excuse me, hearing officer, I would object. This is beyond the scope of direct and cross and any questions of the board.
I understand. I'm going to give Ms. Semino some leeway. She's been patiently waiting. So if they can answer the questions, please do so and get to the point. Thank you.
This is Mr. Paul Wade. I have not.
Okay.
I have not.
Okay, the second question is, there was a lot of discussion about the California Air Resources Board, CARB. Does the California Air Resources, does CARB use satellite data? And how does CARB use remote sensing and provide data on air quality? And what is your opinion on satellite data accuracy? And would you explain if anybody has that? Does anybody have that expertise or know what CARB does?
Relative to this specific question, no.
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 Is satellite data useful to expand the toolbox for decision makers and rulemaking and regulators' ability to feasibly enforce permits?
Are you talking specifically about what we're here for today in this
Yes.
rulemaking?
Because places, does EPA use satellite data in evaluating the NACs?
Objection, Your Honor. There's multiple questions. These people have outlined their expertise and said they're not familiar with this. It's honestly a waste of the board's time at this point.
I understand. If you understand the question, go ahead and answer. Dr. McMillan.
That is beyond the scope of my expertise.
Okay, have you, I just want to ask these questions to get them into the record. Have you used satellite data sets in the EPA EJ tool? And does the satellite data address specific air quality? Because we talked a lot about the EJ tool and what it does and doesn't do. Do you know whether or not we can, that it address specific air quality issues?
I'm a frequent user
Yes
of
or no? You can ask yes or no if you don't know it.
I understood your question.
Okay.
I'm a frequent user of the EJ screening tool, and I guess if EPA were to put satellite data in that to inform our understanding of cumulative impacts, then we would use that.
Okay. What if EHD entered the satellite data into the EPA EJ tool to look at that? Would that be something that they could use?
I don't have an opinion on that.
Okay.
I think the general concept is that as data become available and useful, agencies would use it.
Yes, thank you for that. What type of, how do you know how satellite data is used to help with data criteria with the SIPs?
Ma'am, to all due respect, this is beyond the scope of my testimony.
So,
Officer Sanchez, if I may interrupt, is it appropriate to ask the Ms. Semino if these questions are intended to be directed at this specific panel or a different panel?
no, at this panel, because they talked a lot about this and it was in previous testimony and they had commented on it. So I'm just, based on what they have commented on in their direct testimony, I put these questions together.
Okay,
And,
I understand.
for my last
Honor, I just
question-
wanted to impose, I'm sorry, I'd just like to interpose one more objection. I believe Ms. Simone was actually speaking about the testimony from the other panel yesterday. And when she said previous testimony, because this panel has not spoken about these particular issues.
Okay.
So I'd like a standing objection to these questions that are beyond. their
Mr. Hearing
expertise.
Officer, these are my witnesses, and I strongly object to going down this path. I think we've already established they don't have the foundation to answer the questions. So why keep asking, more detail about
Ms.
questions they can't answer?
Ms.
Okay,
Semino,
I have one more question, and that is, have you ever looked at the Urban Air Quality Explorer, or have you used it in relationship to the health impacts for long-term exposures to pollutants? that are regulated under the NACs?
I have not.
No.
No.
Okay, thank you very much.
Thank you. Thank you, Ms. Mino, for your participation.
All right.
All right, I believe we are done with board questions. I'm going to go down the line. Mr. Mullenberg or Mr. Trujillo, do you have any questions of this panel?
Mr. Hearing Officer, no questions for this panel.
And that's Mr. Mullenberg online?
Yeah, yes, it is. Sorry, Mr. Hearing Officer. I was slow to get to my buttons.
That's fine. I recognize your voice. Mr. Rose or Mr. Olson? No, I'm seeing him signaling no questions. Mr. Calderon?
No questions.
Ms. Richards?
Thank you. I am hoping to cut this very short. My question is to Dr. McMillan. And it's about the use of quantitative data. Is qualitative data generally used as a method of ground truthing quantitative data?
Yes, that is one way of using it.
Thank you. No more questions.
Thank you. Mr. Boutsier or Mr. Harris?
No questions.
City EHD, just going down my list, they're not here. Pueblo Veslada?
No questions.
Mr. Willard is not here.
Yes, sir. This is Captain Ofke. Mr. Willard is unable to be here today, so I will be representing the interests of both Kirtland and the United States Air Force as a whole. No questions, sir.
Thank you. Mr. Jantz or Mr. Locke? Oh, Ms. Locke, I'm sorry.
All right, I'm going to try to be quick but clear. So, and I'll start with my questions for you, Dr. McMullen. So it's nice to meet you. My name is Maslin Locke. I represent the petitioners. I know you've seen me, but I haven't introduced myself to you yet. So just briefly, I know you said you worked for the Colorado Department of Public Health on EJ related things. Is that right?
Yes.
Okay. And the EJ Act in Colorado was passed in 2021. Does that sound right?
Yes.
And the EJ rules promulgated by the Colorado Department of Public Health, that happened in 2023. Does that sound right?
Yes, we just did that this summer.
And you left the Colorado Department of Public Health in 2018?
That's correct.
Okay.
And you asked the question if I had continued to work on EJ while I was at the Department. Environmental justice before the act was promulgated into rule. The department had policies around environmental justice. So it was an active component of the work that I did as a toxicologist in the communities that would have been considered that without being labeled it.
Okay, thank you, Dr. McMillan. And you also just mentioned that you're very familiar with the EJ screen tool. You use it a lot. And if I could have you pull up both Dr. McMullen's rebuttal testimony. Oh, perfect. You're way ahead of me. Okay. So this chart on the right-hand side of the screen, you're listing what's in the proposed rule compared to whether or not it's in EJ screen or CDC places, right? That's page 8 of your rebuttal report.
Page 8?
Yes.
Yeah, just give me a minute.
Okay.
I've got it.
Okay. And it looks to me like you say, and tell me if I'm reading this chart wrong, that our definition of annual diesel particulate matter expressed in micrograms per cubic meter is inconsistent with EJ Screen's diesel PM pollution and sources indicator, according to that chart.
Are you looking at the third one, the annual diesel particulate matter expressed?
Yes, Dr. McMullen.
No, I say that it's that it is consistent. There's a yes right there.
Okay. What about annual particulate matter expressed in micrograms per meter cubed? That's the same, right?
Yes.
Okay. What about traffic proximity and volume? You say that's not in EJ screen?
You can see in my description on the very right-hand side of that row, what is in your rule, your proposed rule, says traffic proximity and volume expressed as a daily traffic count divided by the distance to major roads. In EJ screen, it says it's the proximity and volume is the count of vehicles based on annual average daily traffic at major roads within 500 meters divided by distance in meters. When I read those two, I do not see that they are the same.
Okay. And what about and if you could scroll to page 9 of her report. Sorry, page 11 of the PDF, page 9 of the actual report. Thank you. Okay. And for our indicator in the rule, we say percent of population in households with total household income below 200% of the federal poverty level. Your chart says that's not in EJ screen, and that EJ screen instead says that it's defined as equal to or double the federal poverty level. Is that right? Some version of that?
Yes, what I have what I've written there on the right side of that row is taken from EJ screen.
Okay. And do you know what the federal poverty level is in terms of percentage?
I don't know that offhand.
Okay. Well, okay. Just a couple other questions. Okay, so we'll go back to Colorado. You mentioned Rule 3 in Colorado. That's their EJ rule, right?
Regulation 3 is not their, that's incorrect. Regulation 3 is their construction air permitting regulation that they adopted additional environmental justice considerations based on the EJ Act mandate.
Okay, so it's their permitting regulation with environmental justice considerations.
Correct.
Okay. And do you think that's a good rule?
I think it's an adequate rule. It's a start, and it was a compromise across multiple parties.
Okay. Are you aware that Green Latinos 350.org and Earth Justice is currently suing the Colorado Department of Public Health for failing to be health protective in that rule?
I do.
Okay. All right, I'll move on to you, Mr. Laney. And I just have one question. You said you're familiar with the Bay Area air toxics rule, right?
That's correct.
Okay.
You're referring to 2.5?
Yes.
Okay. I apologize. Rule 2.5.
And that Bay Area rule takes into account overburdened communities when looking at hazard index and cancer risk scores. Is that right?
They do it based upon the composite score of Cal EJ screen.
Okay. And their denial criteria for a cancer risk increase in an overburdened community is 6 in a million, right?
Reflecting their existing programs and population densities, yes.
Okay. And their denial criteria for hazard index in an overburdened community is 1, right?
I believe it is, yes.
And Mr. Wade, I just have a couple questions about the permitting process for portable stationary sources. So in Part 41, if I'm understanding this right, portable stationary permitting requires air dispersion modeling, right?
Yes, it does.
But the EHD can waive that requirement for temporary sources under Part 41?
They can waive that requirement for any permit application if they so choose.
Do you have a sense of how often EHD waives the air dispersion modeling requirement for portable sources?
They have never waived it for any of my portable sources.
Okay, thank you. I have nothing else.
Mr. Pasiniak?
Hello, Dr. McMullen, Mr. Wade, Mr. Laney, thank you for your testimony. I'm Gabe Pasiniak. I represent community interveners, Dr. Sofia Martinez and Manuel Criollo. I hopefully this won't take too long, as everybody says, and I hope that that neither you nor I will be Butch Cassidy and the Sundance Kid and the board members allusion from yesterday. I did want to see if I could get some clarification on the use of overburdened communities. And I'd like to start with you, Dr. McMullen. Dr. McMullen, you cited to the draft November EPA technical guidance for assessing environmental justice and regulatory analysis. I think both in your comments yesterday and also in your rebuttal testimony. Is that correct?
Yes.
And I realize it just came out. Are you generally familiar with what's in there?
I'm generally familiar.
And so I wanted to ask, do you believe that it's appropriate to consider susceptibility and vulnerability factors in identifying overburdened communities?
I would like you to specifically define those, since vulnerability and susceptibility have different meanings depending on who's speaking about those.
Let me actually come back to that then. Were you suggesting that a good starting place to consider thinking about how to identify overburdened communities would be EPA's guidance on those issues?
I think that's a general good place to start, along
Okay.
with other EPA documents that they've put out.
And so I'll come back to the idea of what specific factors might be appropriate to consider when it comes to susceptibility and vulnerability. But in your opinion, is it accepted that in developing an environmental justice regulatory framework, for example, the consideration of susceptibility and vulnerability factors of a specific community might be appropriate?
I think that that's what the intent of, for example, the EJ screening tool attempts to do as a screening level in other state tools.
And would you be surprised that that technical guidance that you cited to in the report says that the EPA uses the term overburdened to describe population groups or communities that experience disproportionate and adverse environmental harms and risks due to greater vulnerability and or susceptibility?
Would you point me to I can go get my document to see what context that's placed in.
It's on page 27.
Can I have a minute to get it?
Sure, yeah, absolutely.
All right, page 27.
Yes, and take your time, and it starts, the EPA uses the term overburdened.
Now, is that coming from their key definitions term, or just it's expressed specifically on this particular page? Or are you using their defined term?
I only have in front of me the,
Oh, okay. You said page 27?
yes. Yeah.
And what paragraph?
The EPA uses the term overburdened to describe population groups or communities that experience disproportionate and adverse environmental harms and risks due to greater vulnerability and or susceptibility.
I'm sorry, I'm not seeing that on page 27.
Okay, give me just 1 second. I'm sorry, it's paginated page 20. It's page 27 of the PDF. So it's the first chapter 4, first paragraph, contributors to environmental justice concerns.
Okay, I see the definition here.
And so would you agree that the EPA is suggesting that using vulnerability and susceptibility to environmental hazards is an appropriate way to go about defining overburdened communities?
I think that it is one factor, along with the other ones that they list in that sentence.
Agreed. Thank you. And did I understand in your testimony yesterday that you agreed that social determinants of health are accepted indicators of vulnerability or susceptibility to air pollution?
I did not say that they are indicators of exposure to air pollution. I said that they're important considerations within an environmental justice framework of considerations for overburdened. But they are separate factors than environmental exposure factors.
No, I'm sorry, I didn't mean to indicate that they were exposure factors, but that they were indicators of vulnerability or susceptibility.
According to EPA's definition here, they would be one indicator.
Great, thank you. And so would it therefore be appropriate to use social determinants of health as indicators, perhaps not exclusively, but as indicators of vulnerability or susceptibility of a community to air pollution harms?
Yes, I think that they're an important factor, which is exactly why I was concerned about the current proposed definition. It excluded the majority of those social determinants of health in the proposed rule.
Understood. And would it, are baseline levels of air pollution, such as environmental air pollution indicators listed in EJ screen, also accepted indicators of vulnerability or susceptibility to air pollution?
I would respectfully disagree with that in its statement as you're stating. I would say that the indicators that are in the EJ screening tool that are environmental indicators sometimes are not necessarily, like I showed yesterday in my demonstration, are not necessarily the actual data of environmental exposures that a community could be exposed to. And therefore, you have to take caution with using that as your only method to define an overburdened community.
Do I remember yesterday though that you testified that for screening purposes that EJ screen is appropriate? And is that a yes?
Yes, as long as we were on the same page with what we meant by screening.
Okay, but for example, I thought I heard you say that using it in defining an overburdened community would be appropriate.
Using US EPA's EJ screen in helping to define an overburdened community, I believe is appropriate.
And using the environmental air pollution indicators listed in EJ screen as some of the factors in identifying an overburdened community, would that be appropriate?
I think they are appropriate as some of the factors, but not the only ones, which is why EPA has their EJ index and their supplemental index scores, so that it includes that along with other very important factors.
Understood, thank you. And then you testified yesterday that you believe that that one of the problems with the overburdened communities definition of proposed rule was the percentile level. Is that correct?
Yes.
And that your objection was that the level was not 80% because that was EPA's recommended level. Is that correct?
I think that that's an appropriate 80th percentile is appropriate and more consistent with what states like Colorado and other states have done.
And in your understanding, does EPA say that that's a hard and fast level?
They do not say it's a hard and fast level.
Okay. And are you, I'm sorry, give me just 1 second. So would you support a definition of overburdened communities that included any census block group where the community was in the 80th percentile for any vulnerability or susceptibility factor in EJ screen?
No.
And why not?
Because any factor by in and of itself, there's multiple factors in EPA's, that's why they created a tool that integrates both the environmental factors, the social determinants of health, and the health indicators. But their EJ index, which is intended to be a representation of cumulative impact, is appropriate. So taking one single factor by itself and designating a community based on one factor that may not be representative of the actual data, I think is misleading and inappropriate.
And Ms. McMullen, did you,
Doctor.
I'm sorry.
Thank you.
Thank you for correcting me. Dr. McMullen, did you work on the proposed changes, the proposed regulatory changes, which I understand that there was some things that you felt like you all couldn't comment on and just highlighted, but there were some red lines. And I think it was docket 189.5.
We did.
And did you all redline the definition of overburdened communities in that proposal?
We have not overlined that, and that's why we would like to consider, after I've heard all of this and the information, that we would like to consider to remove this from the docket. Because our red line version, after we've heard from the board and our testimonies over the last few days, we would like to remove this as one of our red line version. We've discussed it as experts to remove it as one of the proposed versions.
Okay, but right now it is in the docket, and you did propose a definition of overburdened community that essentially had the department establish what that definition of overburdened community would be. Is that correct?
That's correct.
And so you didn't propose a specific definition of overburdened community. Is that correct?
I specifically did not write that into there because I wrote in my testimony that I thought that it needed a lot of other changes to it before there was a proposed definition. I felt like this was so misconstrued or miswritten that I couldn't do it justice with just going ahead and redlining it. It needed a complete rewrite.
Thank you, Dr. McMullen. Given that there was no specific suggestion, does that mean that in your opinion, there could be more than one valid definition of overburdened community?
Well, you can see that from different states that they do use different definitions.
Thank you. And would it surprise you that the EPA says in its technical guidance that the concepts of susceptibility and vulnerability can be used to identify population groups of concern? For example, profiles can be constructed to combine available data on baseline health and demographic information to identify susceptible or vulnerable population groups, and then use combinations of demographic, education, poverty, and environmental data to describe them?
I think, yes, you can use a variety of different tools.
Great, thank you. And then yesterday, I think I heard you say that one important factor of what would be to the board in response to the board's questions, that one important factor of a EJ rule would be, and process would be, meaningful involvement from the community. Is that correct?
Yes, that is one of the key fundamental components of environmental justice principles.
And in your opinion, would community members proposing regulation potentially be a way to have meaningful involvement?
I think that is one way of having meaningful involvement.
And do you think that, given that you've testified that there can be multiple different definitions of an overburdened community that could be valid, and having community members propose different definitions of an overburdened community could be a way to get to a valid definition?
I think that multiple parties can propose, yes.
Great, thank you. No more questions for you, Dr. McMullen.
Thank you very much.
And just one question, I think, for Mr. Laney, and I apologize, it was a long day yesterday, so it's possible it was Mr. Wade who testified to this, and it's even possible I've got the wrong panel, in which case I will withdraw the question. But Mr. Laney, I think it was you. Do I recall that you compared the California screening tool to the EPA EJ screen when it came to cancer risk rates?
You had the wrong person.
Oh, no. All right. Mr. Wade, that wasn't you, was it? Or Mr. Laney, it wasn't you, was it?
No, it was not me.
Okay, well, in that case, I apologize. I'm a bad attorney.
Mr. Domenici, I've been allowing up to 10 minutes for a redirect or less.
This will be less, hopefully. Dr. McMullen, what would you suggest as a method to develop a definition of overburdened community and a corresponding map for Bernalillo County based on the work you've done to date and the testimony you've heard.
I would, sure,
And I understand this is would be for screening purposes only.
correct. Sure. Based on what I've heard, based on the testimonies and what we've discussed, I believe that using the EPA's environmental justice screening tool would be with their supplemental index, if there's a supplemental index that is above, probably greater than or equal to above 80th percentile in one of their supplemental indexes, using a 1 mile radius average, which can be easily done in the current report with EJ's screen. The reason I state that is that supplemental index, those values have been intended to evaluate what EPA considers all the various critical factors to say as a representation of a potentially cumulatively impacted community. So it addresses the cumulative impact factors.
And do you think as a starting point that perhaps using that screen and then requiring the state TAPS regulations to apply to the communities identified in that screen would be a good starting point?
Yes, I do.
Thank you, Doctor. That's all I have for this panel.
Any follow-up from the board? Thank you. I think this panel is done. Thank you very much. We will take a 14-minute break.
Hey, Chad. Good, good. Sounds like things are going a lot better this morning. Yep.
I would expect, we didn't talk about the cooling, but I would expect that it didn't hurt, you know, probably would have gone about the same either way if what they found was all that happened, you know, but they said it's fairly normal for, you know, to find some bleeding like that through a vaginal burn.
Right. Right. No, I mean, and that was, you know, obviously, you know, they end up with the cone head as happened and all of that. So yeah, right, right. So, well, that's a huge relief, and very happy for you guys. Hold on just a second here. Hello, Dal Mullenberg.
Hey, Dal, this is Kelsey. Your mic is on Zoom.
Oh, sorry.
All right, we'll resume. Who do we have on the panel here, Mr. Domenici?
Robert Caldwell on the right, Robert Wood in the middle, and David Otoski on the left.
All right, Mr. Wood, Mr. Caldwell, I'm trying to read my notes, and Mr. Otoski, if you can raise your right hand, please. Do you swear to tell the truth in this proceeding? Okay, Mr. Domenici is going to have some questions of you.
Mr. Otoski, where did you grow up, sir? Turn your mic on, I think.
I grew up in Albuquerque, New Mexico, 69 years ago, even though I look younger.
Do you consider yourself a member of this community?
I do.
Do you consider your business a member of this community?
I definitely do.
Can you describe what your, identify your business and describe briefly what it does?
The name of my company is Mountain States Constructors. We're a heavy civil contractor. We currently have 2 portable permits in the city, one for an asphalt plant and one for a recycle plant.
What kind of jobs do you do?
We do highway construction throughout the state, and we also do airport construction.
Can you describe a circumstance? Well, I'd like you to describe what you use those portable crushers for. Give an example, or just let the board know how they're utilized.
Normally, what we do is we'll take material from an existing road project. We will either screen it or crush it and reuse that material on the job site.
And why do you do that as opposed to transporting it to another location to crush it or reuse it?
What we try and do, it's economical to do that. It keeps us from having to haul long distances with the material, and it makes more sense to be able to reuse, recycle material on the job site than it does to bring in brand new material.
Is safety a concern on your projects?
Safety is a huge concern. We are currently doing a project at La Bajada Hill that everybody is aware of, I'm sure, because over the weekend, virtually any weekend, they do over 100 tickets, speeding tickets to the public. So when we can keep our employees and our trucking on site, we have a lot fewer incidences.
Can you describe the situation that you most recently used your portable crusher?
We were doing a job on I-40 at Coors approximately a year ago. We applied for an air quality permit to relocate an approved recycle plant. It took over 5 months to get that approval, and we were just moving the plant approximately 1 mile. And the location that we used was not close to anything at all, but it took over a mile or over 5 months to do it. So in that period of time, we hauled over 1,000 truckloads twice just to bring material in and out of the project because of the length of time it took to get the air quality permit. We also did a project at the city dump, and one of the things that we were supposed to do there as well is recycle concrete that the city dump had. Took over 5 months to get a permit. We were totally done with the project and had to have the city extend the project in order to be able to crush the material, which only took a week. We currently have a project at Double Eagle 2 Airport, and there's approximately 20,000 tons of hot mix on that we'll be doing in the springtime. All that material will be hauled from Las Lunas because we didn't even try to apply for a relocation of our asphalt plant because the time frame would not allow us to do that. We'd be done technically with the job before we could even get a permit to move the plant.
How does uncertainty regarding the ability to use a portable plant affect the bidding, the contract price, and the overall benefit to the public?
All of our pricing is higher when we're bidding in the city of Albuquerque because we have operations in the Las Lunas area out in the middle of nowhere that allow us to efficiently and correctly set up plants. And everything we do, we go through Paul Wade at his firm and make sure that everything we do is done properly and correctly. We have tried several times to move in different locations in the Albuquerque area just to try and be more efficient doing the job and be more cost effective for the whole community, and to keep from driving hundreds and hundreds and hundreds of trucks on the road. And virtually every single road, every single job that we do goes through I-25 in the southern part of the city because of our location of our plant in Las Lunas. So we are driving hundreds of trucks virtually every single day anytime we do work in the Albuquerque area.
what are your, can you describe your concerns regarding some of the consequences of this, if this regulation goes into effect, either direct or indirect, unanticipated consequences?
If this went into effect, we virtually would not be able to relocate or recycle any material on site in the Albuquerque, Bernalillo County area ever. It would not make sense to do that in such a manner where we wouldn't have enough time on the job. And what happens is with the city and with the state, they give you a certain amount of time to do the job. And if you effectively cannot complete the job in that time frame, then there's liquidated damages. We've been in business since 1958. We've never had a single day of liquidated damages, and I'm proud of that concept, and hopefully that'll always stay that way. So based on that, there's no way that I'm going to ever bid a job relying on the Air Quality Bureau to give me a permit in time to do that project.
And that would be under this current regulation?
That's correct.
This proposed regulation?
Yes.
Okay. Thank you. I'm going to turn to, well, let me ask one final question. Can you just generally describe how involved you've been in this process since you became aware of it?
Well, unfortunately, I was not aware of it, nor were any of my colleagues or very few people from the very beginning. We came in when we found out about it, and as soon as we did, I have been heavily involved in this process.
Mr. Wood, would you please introduce yourself to the board?
My name's Bob Wood. I'm with Albuquerque Asphalt.
Describe where you came from and your connections to this community.
Well, I was born here. I grew up in Cortez, Colorado. Went to school at Texas Tech, got a bachelor's degree in civil engineering. And I moved back here in 1985 and started working at Albuquerque Asphalt.
And describe what Albuquerque Asphalt does currently.
Well, we're basically a public works contractor. We do civil projects for the New Mexico Department of Transportation, the city of Albuquerque, Bernalillo County, and the surrounding counties.
And describe how you generate asphalt, just to give just a brief description of the process you use.
Well, we actually buy our virgin aggregate from Mountain States. That's Dave's company. And we run it through our plant with oil and then our asphalt cement. And then we try and use as much recycled asphalt as we can, depending on what specification that we're making. But we do a lot of recycling, concrete and asphalt. We do a lot of rehabilitation projects. So instead of taking broken curb and gutter and sidewalk and drive pads, things like that, and taking them to a landfill, we recycle them and make base course that goes under the new roads.
And with respect to your facility, can you tell the board where it's located?
It's located, the address is 5012 Broadway, so it's about a 1.5 miles south of Rio Bravo on the east side of Broadway.
When did you create that facility?
It was the fall of 2017 is when we bought the property, and then January of 2019. Well, we first bought our asphalt plant in the fall of 17, but we had to set it up in Valencia County until we could go through the purchase of the property and getting our permits and things like that. So it was
And
January of 2019 when we started operating our plant there.
have you had to modify your permit since you've started operations?
Yes, we did 2 technical modifications.
And do you anticipate you might need modifications in the future?
Yes, I would say so. It's kind of a normal course of business.
And are you concerned about whether you could, well, describe your concerns about your ability to modify your permit under this proposed regulation?
Well, the regulation that we work under for our permit in the county is a little bit different than the state in that it's all of our equipment is listed by serial number and model number. And if we change that, we have to go through the technical modification, even if it's the same piece of equipment, just a different serial number, we have to modify it.
And is the asphalt processing or asphalt production business, does it have changing needs and techniques that you would need to perhaps comply with it out into the future?
I would say yes. One of the changes that has come recently is we used to produce asphalt with, it's called hydrated lime, which is a powder that is in a silo, and new technology became available, and we now have a liquid additive called Evotherm that we purchased, and so that's how we use that instead of hydrated lime. And so those are changes to the technology and specifications that we need to adapt to.
What does that change do as far as your emissions? The change you just described?
I would say it lowered our emissions.
Was that one of the reasons you chose to change that process?
Yes, that was one of the big reasons. Plus it's just a little more convenient to use the liquid additive, and it also has some benefits. It allows us to manufacture the asphalt at a lower temperature, which also lowers the emissions.
What concerns do you have regarding the consequences of this regulation if it goes into effect as proposed?
Well, the technical modifications is a big problem. Also, relocation of, because we also have crushers, and so we're currently in the running for a project on I-25 in Comanche and Montgomery interchanges. It's a big project. If we're successful, we would like to do the same thing that Dave did on his I-40 project and relocate one of our crushers on site, so we don't have to haul all the demolition material through town all the way to one of our other sites to crush it and bring it back. So those are some of the big problems. Is just, I mean, we live with and we operate by permits. So if we can't get a permit, big problem.
How many employees do you have?
It fluctuates. We go between 180 and 200.
Describe your involvement in this process since you became aware of it.
Well, obviously we were very concerned. And it was troubling that we didn't have any input until after it was already submitted to the board. So I've just been trying to get the community made aware of what was going on and some of the consequences that will happen to our community if it's adopted as it is written.
Were you involved in the decision to hire Montrose and to hire Dr. McMillan to be available to inform this board about their concerns about this rule?
Yes.
I'm going to turn to you now, Mr. Caldwell, and ask you to introduce yourself to the board.
My name is Robert Caldwell. I'm with BlackRock Services, which is a aggregate and asphalt commercial material supply company. I'm different in the fact that with Mountain States and Albuquerque Asphalt, they also self-perform the work. I do not, and so we provide materials just to other contractors that may be competing with these gentlemen. Born and raised in Socorro, New Mexico. Have a business degree from UNM with a focus of production and operations management. And I have several air quality permits. 2 of them are for the state of New Mexico and 3 of them are in Bernalillo County. I have a mining operation in Valencia County. And so for the hot mix asphalt plant, those materials, the virgin materials are brought in from Valencia County. We also have a screening operation in Santa Fe County where we screen materials, cinder materials for an MDOT for inclement weather, for cinder block plants and specialty soils organizations that provide specialty soils. I also have a recycle plant as well, a permit for a plant for recycled asphalt products. So I also, one of those permits was for the establishment of a new hot mix asphalt plant located on Carmody and Alexander.
What's a close milestone so people know where that is? Is there something nearby you could describe?
Yeah, so that is, you guys where American Home Furniture is at, it's on the north side of that. So a lot of people drive past there to get to Costco. So.
Okay, what concerns do you have about the impacts if this proposed rule goes into effect with respect to your operations and other things you're involved in?
So that permitting process for the new facility, that process took approximately 2 years to be able to get that facility permitted. And I don't think that any one of us here are necessarily concerned with what it takes to get a facility permitted and the due process. I think what the big concern is the amount of time that it takes to get it accomplished, and the amount of modeling that's required, and the technicalities that are required, and the overall record keeping that's required. And so I think that a lot of individuals here, they don't fully understand the level of recording and reporting requirements that go along with this on a daily basis. That's hourly reporting, daily reporting, monthly reporting, and annual reporting. And it's actually quite extensive. I am concerned in the fact that just like these gentlemen here, we will have to go through modifications to our permits. Equipment, it has a lifespan to it. And so we have to plan to be able to replace this equipment. For my operation, we deal with all different types of material specifications. Some of those are stone matrix asphalt, what Mr. Wood here had mentioned, warm mix asphalt. And then there's some additional requirements that are coming on to hot plants and to crushers called environmental product declarations. And essentially what that is it's yet another layer of documentation to reduce our overall carbon footprint. So we have to establish a baseline. And similar to the proposed rule that we're looking at now, there's a lack of definition as to how do we accomplish these things. These are obviously incredibly complicated matters. I mean, there's you guys for several days have listened to several experts. And so my concern is that we will not be able to properly adapt and modify and change for the betterment of the overall industry from a community perspective, from an environmental perspective, in a timely and economical manner. Additionally, tied to those environmental product declarations, you've heard these two gentlemen speak a lot about recycled products, recycled asphalt products, and there's huge benefits to adding recycled asphalt products to your hot mix asphalt mix designs. From a global perspective, aggregates are in short supply. We're also trying to reduce the amount of oil of asphalt cement that goes into our products, which also helps make the final product more economical for the taxpayer. All of these things will require us to implement some different technologies into our facilities, or will require us to be able to make modifications that allow us to input more recycled products into the plants themselves. And the way that everything is moving so quickly with regards to regulation, under this current setup, we would not be able to meet those requirements that say FHWA, which is the federal highway funding, or state funding, would allow us to effectively participate in those projects, because we wouldn't be able to meet some of the requirements because we couldn't get it permitted in time for those specific projects.
Can you just describe, from your point of view, over the last 30 years, how the shift in the asphalt industry has occurred with respect to air quality issues?
Yeah, so one of the first air quality permits that I had was a pre-existing permit. It was a relatively older permit, and I had to make some modifications to that permit to try and remove some older equipment and bring in some newer, older equipment. And so throughout that process, I have been a part of roundtable, community roundtable meetings. And just for comparison's sake, that particular permit is 14 pages long. The new permit that I have for the new facility is 30 pages long. And the recording, reporting, and documentation requirements for that permit are incredibly difficult, very duplicative, and in several instances, they don't necessarily add a beneficial gain to the overall facility operation as it relates to reducing or controlling emissions. And I think that some of that is part of just trying to show that to the community that the environmental department is trying to implement restrictions, but because there's a lack of understanding of these facilities, maybe those restrictions do nothing at all other than add a burden to the company, which ultimately increases cost to the final product, which has no gain at all to the community.
Let me ask for this would be probably for you, Mr. Wood, can you describe the inspection process, inspection compliance process that the Environmental Health Department does with your facility?
We have a yearly stack test that we have to do. And then they really can do a physical inspection at any time. We just went through one of those, and well, they actually haven't come to physically inspect it yet. They gave us the report that they wanted and gave us a week to put it together, and it was a little over 8,000 pages that we submitted.
And then they're going to follow that up with a physical inspection?
Yes, they scheduled it, but then they canceled it and said they would reschedule.
Can you give the board an approximation of how many hours of your personal time you've spent engaged in this rulemaking process since you became aware of it?
I probably spent 1 to 2 days a week, several evenings, and my wife and I canceled a trip to Italy this fall because of this. She was not very happy.
Mr. Caldwell, can you describe how many hours you've spent on this, or days, however you want to reflect it?
Similar to Bob, it's 1 to 2 days a week, evenings. I try to be as involved as I possibly can. It's very, very serious matter to us. It's our livelihood. We spend more time at our facilities than most people do at home, and it's how our people survive. It's how we survive, and we are a part of the community, and so we would love to have a voice as well. So,
Mr. Otoski, I didn't ask you. So, how many employees does Mountain States have?
We currently have 300 employees.
And if I understand, you are the president?
That is correct.
So I would assume you have quite a few duties as the president of a 300-person major highway contractor.
Yes, I do.
And how much time have you been able to, or have you chosen to carve out of your other duties to participate in this process?
Well, I've spent several hours every week as well, and some of my employees have been involved in putting information together as well.
That's all the questions I have.
I just want to make one more
Oh,
comment
sure.
real quick. We did a job, airport job in Santa Fe, and they have stricter rules than Albuquerque does. But just to let you know, there wasn't a single asphalt supplier in Santa Fe that would supply mix for the project. And we were going to have to haul it all the way from Los Lunas. And the city actually came together when we told them that we would be able to cut the time frame that the runway would be shut down in half if they allowed us to put an asphalt plant on site. And we had a permit to do that in less than 30 days because they saw how good that would be for the overall community. And that's what happens when we can't get a permit in time. We go outside and the projects take way longer, and the travel for vehicles is way greater than it would be if we were allowed to have a permit on site. Approved permit. Not a single one of us does not agree that we have to have quality air permits. We just, the one that's being proposed is not, in our opinion, a permit that would be recognized by the business community in New Mexico and Bernalillo County.
Thank you.
Thank you. I believe we have some board questions. Board Member Lewis, are you still with us? Do you have any questions?
Yes, I am. Thank you very much. First of all, I want to thank the panel. I think this has been very informative. And I appreciate your concerns over length of permitting process. I tried to change some windows in a house in Santa Fe and waited 18 months for the permit, so I can really appreciate the frustration. And Mr. Caldwell, I really appreciate you mentioning how quickly this process was moving, because that is a nice contrast to some other accusations of how long it's taking. So having said all of that, one of the things that I'm taking home from this is that the problem is not that there is opposition to having this type of rule, that it really is one of time, and especially additional time that would be required for these temporary projects that require movement of equipment. Is that a fair statement? Would you agree with that?
If some of you can.
I don't know if that's a totally fair statement from the standpoint that we agree with the rule because of what's going to be involved in order to be able to get a permit. If this rule were enacted, we would be looking at anywhere from a year to 4 years just to get a permit in order to do something. Obviously, from a standpoint of doing work, there's no way in the world that we would ever apply for a permit in Bernalillo County to do any type of recycling work, which would make it more beneficial for every single person in town than to haul all the material through town. So I'm going to say no, that would not be accurate if we can't get a permit that is reasonable in a reasonable amount of time.
Understood. I think my point was more, it's not the principle of addressing the environmental equity. The issue really is that the permitting process is too cumbersome. And I mean, it sounds to me like part of this concern is the 5 months that is now your baseline for getting any permit through. Is that a fair assessment?
I can only speak for Mountain States, but yes, that would be correct.
Thank you. So what I'm getting at is that, you know, as I'm listening to all of this, we've heard many of the technical expert or the business community come in, and their objection, and as well as some of the federal facilities, really has to do with the time that this process is taking. And, you know, that's a fundamental different direction for the board to think about in how this rule gets promulgated. And it sounds like there's a need to integrate the process and to review maybe the baseline permitting process so that this is not going to add to your burden. Is that a fair assessment?
This is Robert Caldwell of BlackRock. I would say that it's not necessarily exclusive of the time so much as it is the vagueness of how do we navigate through this permitting process, and understanding, you know, businesses are not able to manage what they do not know. And so if we can add some definition, some clear definition, so we can understand how it is that we can operate, you know, responsibly, and how we can plan for our organizations. And that is a key objective here. Is I think there's just so much vagueness that we don't understand exactly how this is going to affect us. And so it is time, and it's definition. Yeah, so that.
This is Bob Wood. I just want to add with some of the things that we would have to, some of the metrics that they were trying to hold us to in this new language. I have a concern of even getting approved for a technical revision or a new permit.
Okay, thank you very much. No further questions.
I'm going to start on this end. Vice Chair Richards, do you have any questions?
I have a couple questions, just very quick, because we're being cognizant of time. So I'm wondering, it sounds like the regulations at the state level may be different, the Part 41, than they are for, I should say Part 41 for the county, but they're different at the state level, and you said they're more strict or less strict? Yes, whomever, I can't remember.
Well,
Sorry.
they are a little bit different in, as far as like if a piece of equipment breaks down, we give them a letter and say, hey, we're replacing this piece with another piece. Here's the emissions, that it meets our current permit emissions, but it is a different piece of equipment. And they allow us to use something different while we're working on the breakdown. And then if you want to make a permanent replacement, then that's a little bit different process. But it's not, you're not shut down basically if something breaks down and waiting on a technical revision.
And so you're saying you are shut down under the regulations here? Okay.
Yeah, that's correct. There's almost a fear that even if you could replace something with a less emitting substitute, that the time frame to get that approved would not be economical to you in order to be able to finish that particular project.
And then my other question is I'm so glad you're here because you know what costs are for operating business. What is the cost for this type of permit? When I say that, I'm sorry, it's not the cost, it's the fee that I'm asking about that EHD charges.
The fee, from BlackRock's perspective, it's all based upon, I think what they call polluting. It's the amount of annual pollution, but the annual fee for the new facility is just over $10,000 annually. And you have a fee with each facility.
Thank you. I'm sorry, just one last question. I was going to ask you, Mr. Sorry, I forgot your name, but the one, BlackRock?
Caldwell.
I'm sorry, it's Caldwell?
Caldwell.
Okay, apologies. When I know you just mentioned a new asphalt plant in the area behind Albuquerque Furniture, was there a public information hearing on that?
Yeah, so it's part of your requirements to send out all of your public notifications, right? So you have to post your yellow board at the actual physical facility. You have to give public notice in the Albuquerque Journal, and then you also have to notify the community within a half-mile radius. What we did is we actually went outside of that half-mile radius and we notified the next community over. In addition to that, we put together a fact sheet, and that fact sheet introduced, number one, the company, number two, who the owners were, number three, we described the project, number four, we described the implementation of blue smoke systems and what we were doing to further reduce our emissions. Number five, we also communicated the traffic flow and how it may affect the community. And so in that particular instance, I think we had one or two individuals that had sent an email back. We also had inside of that communication, we invited people to come over, to have a cup of coffee and discuss any concern that they had. And I had no takers, but I also might add that I had petitioning on the corner of the facility saying that we didn't give public notice. And I've had our facility spray painted multiple times and things of that nature.
That's all I had, hearing officer.
Board member Coleman.
Yes, thank you. Just a couple. and I guess any of you can answer this or all of you can answer this, but how often does EHD do physical inspections?
I have had them at my facility several times per year. They do it anytime there's any call, any 411, is that the phone number? If there's any 311, if there's any complaint, but at a minimum, I get them twice per year.
And do they only come out when there's a complaint, or do they also do like,
They do random checks
Random
as
checks.
well. Yeah.
and how often do those happen?
Minimum
That's
of
twice a year? Okay.
twice per year.
Is that about the same for all of you? Okay. Kitty, Member Richards, sorry, alluded to this question, but do you all ever do outreach to the community outside of the required permitting requirements, just like randomly?
BlackRock Services has, so we actually used to participate with the school there, and I apologize, I cannot remember the school there in the South Valley. I do apologize for that. But multiple times we would go, we would communicate with the school district. We would come in and we would donate things to the school because we wanted to be a part of the community. We also, the wildlife refuge, there would be some of us that would go in and have, I think at the time it was called morning coffee with the cranes or something like that. I don't remember the exact terminology, but we did have individuals who would participate with that to try and get involved as we are a member of the community.
Thanks. And then my last question is a little complicated, so if you could try to be brief, that would be good because of the time thing. But can you just talk a little bit about what kinds of emission control technologies are currently required for you and whether you ever do additional ones beyond what's required by permit?
Mountain States, we have the latest technology available to us from the manufacturer. And in every single situation, we use water, as was described earlier, in order to make sure. In some locations, we actually pave the road to decrease the amount of dust in the area. But virtually every single one of our operations, we have a minimum of 2 water trucks that are running full time while we're operating. We have, at each facility, we have monitors that are part of our operation, but they monitor dust. And if they have any issues, we often shut down to repair those issues before we start operating again.
Yes, Bob. So when we first bought our plant, we had been through several public meetings on our crushing permits. So we were well aware of the concern in the community. And so it wasn't required, but we opted for a blue smoke recovery system. It captures and recycles the blue smoke so it doesn't get into the air. That was about, I think it was about an additional $150,000 option plus the extra cost in shipping, which was from Tennessee. And then after we got our permit, we had one of the pieces of equipment that was right next to our asphalt plant was a crusher where we crushed the millings, the asphalt millings, and resize them and use that in our new hot mix. And so that was a diesel powered crusher. And so we have since, that was a technical revision to do this. We bought an electric crusher and then we extended our power out to, I don't know, it's probably 100 feet. Considerable expense on that one. I don't remember the number, but the crusher was 800,000, but it was an additional cost for the moving the power.
It's Robert. So we as it relates to additional emission controls, so all of our haul roads are paved. We have to we keep the roads clean. We add water to them. We have a blue smoke recovery system similar to Bob's, which ours was around $100,000. Additionally, we have water sprays at all the drops. We also had included enclosures as well to try and eliminate any PM from drop points. And then we also added some photo eye sensors at the feed bins to be able to, when the loader crosses that barrier, a mist of water will come to try and encapsulate all of that whenever you're moving the material into the feed bins. We also, the recycle crusher that we have for the new facility is electric. The whole facility runs on line power. And we also ensure that facility, we only permitted for natural gas because it is a cleaner, more efficient way.
Thanks. And just to clarify, are all the things that you just mentioned part of your permit requirements, or is that beyond the permit requirements?
So throughout the permitting process, so what happens is you're trying to, we didn't have to implement any of that. In short, we didn't have to implement any of that. We chose to implement that. And because we chose to implement that, and we communicated that in our pre-application and final application and in our modeling process, some of those became permit requirements.
Board Member Eberline?
I have no questions. Thank you.
Start on the other Board Member Armijo.
Yes, I have just a couple of questions. You can answer this jointly or singularly if you'd like.
But one at a time.
Huh?
But one at a time.
One at a time, yes. Do you believe that there are overburdened communities in Bernalillo County?
So I'm born and raised here in New Mexico, and I think that I believe that we have high poverty rates here. I believe that we don't have a tremendous amount of infrastructure here. We're high desert. And so I think that there are several factors that can contribute to overburdened communities.
Excuse me, I'm just talking about overburdened with regards to air quality.
Do I believe that we have overburdened communities with regards to air quality?
Yes.
Well, I think I wouldn't say that I'm qualified to say that because I'm not a doctor. But what I do know is I do know that there is a lot of industry in south of Albuquerque, and I also know that we shut down a facility that's in the south part of Albuquerque. I do know that other industries have moved out of there, and so does that answer your question?
Sort of. Mr. Wood?
So I have yet to see a real definition of overburdened community. I mean, I've seen there's several definitions out there. Some communities have spent 18 months working on just what the definition that they were going to be working with on overburdened communities. So I'm not really sure what that means, but I spend 10 hours a day at right next to my asphalt plant. I'm not afraid to go there. I'm sure there's probably areas of town that have more emissions in the air than others. But there's a couple of places on the environmental department's website that show that the air is generally good in Albuquerque. And not to say that we're all not trying to make it better, and I think we need to make it better. But I'm not afraid to go to work.
Mr. Otoski, is that how you say it? I'm sorry.
Yes. I guess I would concur with what Bob Wood has to say. I have an operation in a location that is 8 miles from any city. And I was just told there's a potential that I might be in one, so I am totally confused as to what the accurate description would be.
Okay. And I understand that you all have testified how onerous the process right now is to get a permit. Is that pretty much your testimony? And I believe that one of the experts right before you said, we need to have rules that are simple and clear. And if this rule is simple and clear and can be done in conjunction with your other permitting, is there a possibility that it won't take as long as you anticipate?
So if I have a problem with doing it in conjunction with, because if you don't get through the first one, we don't want to spend money to do the second one.
I understand.
Yeah.
I also would just like to add that obviously these are very, very complicated matters whenever you go through the modeling process. And so regardless of what may or may not get passed or approved, you still have a bottleneck with the environmental health department in the fact that they have 2 modeling reviewers. And so those types of individuals are not easy to find either. And so even if there was absolutely no change to the process today, I would like to go back and recall that it took me 2 years just to get through the existing process because there are not enough qualified individuals to be able to adequately review your information and process it in a timely manner.
I thank you very much. Appreciate your showing up.
Member Galuski?
Thanks, and I really appreciate you guys coming out. And I'm interested in learning more about how you do your business. My dad ran an engineering business in Southeast Texas. Oh,
speak.
Okay. My father ran an engineering business in Southeast Texas, and so I grew up hearing about permitting processes and all this sort of stuff. And I know that often the people who know most about the permitting process are you guys, the people who are actually applying for them. And often, and I think Mr. Caldwell touched on this, you see inefficiencies in the process where you know what the environmental goals are, and you see that there are steps that don't help anything to even meet those environmental goals. And I've heard, I think it was Mr. Otoski mentioned, subject to permits for a portable crusher, for example. If you don't have that, then you have trucks driving long distances, which would seem to kind of negate the environmental benefits. So I'm wondering, just under the current permitting regime, are there things that you could imagine doing, simple things that would make it more straightforward for you to get your permits? And that may not be a simple question because it may depend on specific pieces of equipment, but anything even in general that you could imagine might smooth things.
I think that, you know, number one would just be, in my opinion, this is just my perspective. I think the environmental health department, the air quality department tries to do the best job that they possibly can with the amount of resource that they have and then the amount of personnel that they have. I think that what tends to slow this process down, if I'm just being 100% transparent, is they're afraid. They're afraid to make a mistake, because if they make a mistake in that process, somebody wants to sue or whatever's the case. And so, for instance, I know that with my permit, they asked for, several other things that weren't typical of the process because they were so terrified that if they made a mistake, that it was going to end up in contention. So I don't know how to resolve that matter other than, number one, they need more qualified people to add to their staff. I would also say that there needs to be some particular verbiage added to the rule that allows for administrative and technical revisions that are able to be streamlined. For instance, if you wanted to do a like-for-like equipment substitution that didn't increase emissions, then that should not take 90 days, and it does take 90 days at times. I would also say that in the event that there is a need to relocate, such as in David and Bob's situation, then yeah, you look at the overall project as a whole and say, okay, this isn't going to be here except for the duration of the project, and let's look at the total environmental impact, and it's actually a reduction of that impact, and sort of use some common sense along with the data that's there, and I think that would help streamline things, in my opinion.
Thanks.
One other thing that I think could help too, the public input obviously is incredibly important and needs to be heard. But if we go through the process and meet every single requirement and then go to a hearing and 1 or 2 or 10 people are against it, even though you've met everything, now your process is increased unbelievably just to go through that process. So if there was a way that could be implemented from a standpoint where their input was done sooner, so we know what to address, that'd be helpful also.
And Mr. Wood, do you have any thoughts about this? Current ways to streamline the process?
I don't know about streamlining it, but just kind of to follow up on Robert mentioned and what I mentioned a while ago is it'd be nice to have a simple process to swap equipment out because right now it's serial number specific, and we need to get to a place where you're just looking at the emissions, and if it doesn't matter if it's if it's one manufacturer or another manufacturer, as long as you are at or under those emissions, we should be able to just submit a letter and saying, hey, this is what we're using. Here's our here's our data on that piece of equipment, and it meets our permit emissions requirements, and that would be really helpful.
That's really helpful. Those seem quite reasonable. I only have the authority of my own thoughts, but in particular, like the swapping like for like, that seems like common sense. That shouldn't be so complicated. Mr. Otoski, you mentioned that the public hearings under the current system, sounds like they come a little late and can derail the process. Could you say a little bit more about how that can happen?
We, it's been several years since we did our permit, but we had a public comment and we had 2 people, I think, show up, and the concerns were, if I remember correctly, one was using recycled material, and I can't remember what the other one, it's been several years, but in order to answer those questions and then go back to the city, and at that time they had limited individual resources to be able to look at it, it added another 60 days to the permit. We eventually received the permit, but just those 2 individuals were able to do that. It was a real simple answer to the question from a recycle standpoint, and that individual actually was satisfied at the meeting, but we had to go through the whole process to show what we told him, and it still took another 60 days.
Wow. Yeah.
If I might add to that, so with regards to the public comment, I guess, and again, I have participated in several community roundtables and whatnot in the permitting process. And I guess if we could just, it appears as though it doesn't matter what factual evidence that we put out there and what data we put out there, and we can't manipulate it because we're not smart enough to manipulate that data. I mean, it's super complicated stuff. And so we're not making it up. We're not lying. We're saying this is what it is. And it appears as though that the public just says baloney. We don't believe it. And that is very difficult from our perspective because we don't know how to operate around that.
Public skepticism is you're describing. Let me just type this in. When you purchased property within Albuquerque and Bernalillo County for your businesses, are you basically taking a risk, a business risk, that the regulatory environment will allow you to keep doing your work on that property?
Yeah, so when we were looking for property for our facility, we initially chose one that was a little bit south of where we are now. And it was an M1 zoning, which I guess you can put an asphalt plant in M1, but you have to get a special use permit. Whereas M2, is a heavier category in the industrial property. It's specifically allowed under M2. So we just liked the location. It was further away from the community, and so we had started the air quality permit process. That was a condition on purchasing the properties, was that we were able to get a permit. And there was a lot of opposition, one by the Oro people. They came to my office and told us they were going to fight us forever. And when you have an M1 property, they can do that because it's not specifically zoned for that. So it cost me about $40,000, but we abandoned that site. And so we went to the county and we said, hey, we can't be anywhere but M2 property. Help me find a place. I went to Commissioner Quezada's office and had his people, because he's got to listen to the complaints just like we do. So anyways, we found a M2 property in Albuquerque, doesn't go past the channel that goes right there by Bobby Foster. It doesn't go south of there. And so we're about as south as we can be, and we're right up next to I-25. So, you know, I said, dude, I can't find a different location since we have to be in M2. You know, we can't put an hot plant in residential property or commercial property. It has to, and we don't pick those places. Those zoning is there. So, so yes, I mean, there are instances where you take risks. And that's one of the reasons where it took us so long to, since we bought our plant in 17, we didn't get it set up till 19, is to go through some of those issues.
The other piece of that is under the new permitting requirements and submittal checklist, they won't even deem your permit complete if you can't prove that you're in the properly zoned area. Right. So,
Mr. Toski, do you have anything to add on that?
I do not.
Okay. And for all three of you, you mentioned sort of generally about when you heard about this current rulemaking process, but I wonder if you remember sort of the actual time frame. Because again, I've mentioned that I only joined the board in April. This process has been ongoing for some period of time. Do you remember like month, year, even when you first heard about this process?
Yes, it was the first part of December of last year. Paul Wade sent me an email and said, have you heard about this? And they were the first, we attended the next air quality board meeting and expressed our concerns there.
We're all part of Associated Contractors of New Mexico, and Paul does a lot of work for the members. And so he did inform us at that time.
So I'm also signed up to receive any notifications from the Air Quality Department or Environmental State and Bernalillo County. And I actually did a search, excuse me. I very rarely delete emails just because I always have to go back to them. And I did a search and I couldn't find anything in my inbox because I kept hearing people say, well, you were notified. And I was thinking, well, my gosh, how did I miss such a big thing? And I didn't have any information to that prior to Paul Wade notifying us.
Yeah, that seems problematic because we would obviously, for a successful rulemaking, stakeholders obviously have to be involved. So it seemed like there was a breakdown in communication. I don't know what happened with that. I think we'll have some more conversations with EHD later on today, maybe. I believe that is all I have for right now. Thanks. I appreciate your answers.
Chair Paul.
Thank you all for coming. I wanted to note that I recognize you from many of our meetings, so appreciate your participation in all of this. Just to follow up on what Member Gluski was saying and what you were mentioning about not finding the notice. Yeah, I think it's possible that there was no notice sent out during that open meeting call. I don't recall like if there was enough of a distribution from EHD to stakeholders during that. And I know that's part of the complicated element of this being a community proposal and EHD not necessarily being in support of it, for example. Anyway, I'm gonna try to make these brief and we can all maybe get to lunch. First, for any of you, can you just briefly summarize your what your permits say about your the NACs that you emit and then the HAPs that you emit, or not you, but your properties.
So you're saying how many HAPs?
Yeah, like 10 tons.
Yeah, no, it's so if I'm not mistaken, I would have to look specifically at my permit, but I think the total HAPs that my facility emits is 3.92, I believe. Additionally, I would like to add, so every single year we have to do emissions inventory reporting into the SLICE program. And it's all based on math and spreadsheets and total throughput. And so we quantify all of that, the total HAPs, and typically it's significantly less than what is on those permits. So they are relatively very conservative.
Right, that difference between what you are allowed to permit and what you actually permit is noted. Any other response?
I'd have to go back and check, but I do know on our portable plant, it was so low that when we were doing the project on I-40, because the engine's 150 horsepower and it was so low that it didn't even hardly register. So other than that, we haven't had our asphalt plant in Bernalillo County just because of the long process to get it moved, relocated. So,
Mr. Wood.
Yeah, I'd have to go back to our permit to know the actual numbers, but I don't know. Paul could probably tell you. I think he just went through our permit.
5 what? Right, 5 what? Of 5 tons of all NACs and HAPs? Of all HAPs, a little less than 5 tons of all HAPs. Okay, And the PSD increment for HAPS is 10 tons. Is that accurate? For a single pollutant, sorry.
You need to come up.
Yeah, sorry, he's not on the, I shouldn't be asking him questions. So, okay, thank you for that background, just to get a sense of the size of your facilities. And then you all mentioned control technology or controls that you use. Do you know if those controls qualify as any specific standard of control technology, like BACT, MACT, layer that the consultants talk about?
So the blue smoke recovery systems, I'm pretty sure are a part of one of those acronyms.
Okay. And then Mr. Odowski, did anyone do a analysis of, and it takes a little time for this to go into effect, but you know that this board in the state recently passed Advanced Clean Cars 2 and HDO, the heavy duty omnibus, and the Advanced Clean Trucks bills that were promulgated by California. Do you know if your trucks will be subject to those?
I haven't had a chance to look into it, but
And sorry, I said your trucks, I meant the fleet. If you turn over your fleet and choose to buy new vehicles, because it's, no.
well, you know, a lot of it would depend on the technology. If the batteries are able to last longer than they currently do, because literally some of our trucks just driving from here or from, for example, Double Eagle Airport out to Los Lunas to get material and come all the way back, I may end up having to charge in the middle of the day. And the biggest issue with that too is they have not come up with a long enough period of driving time when you're hauling 22 tons of material. So it's hard for me to say what that'll look like.
So I think for now, at least, it's likely that you'll continue to use ICE vehicles.
Correct.
Okay, understood. And then this is a question for all of you, if you can answer it. We've talked a little bit about the difference between the state regulations and the city regulations. And we also talked about how it sounds like the city could use more staff. And I know that they're also not fully filled out. So they have more of a budget than they have for the staff that they currently have. But do any of you know the price, if you could compare on a relatively equal basis, if you have a facility that's in NMED's jurisdiction and then a facility of a similar type in the city's jurisdiction, which is more expensive for air quality permits?
The city.
Can you tell me why?
So Bob and David will be able to speak more to this because I don't have a hot mix asphalt plant outside of the county, but typically those are more so in remote locations and not as restrictive. And so that overall process, it's just how the facility is set up. It's not set up to move around in the city as it is for a state permit. And so it's just a totally different type of facility, if you
So
will.
in some ways it's irrelevant of the air quality regulation. What I'm trying to get at, I'll just get to my point, which is that my understanding is NMED's fees are higher for air pollutant by pollutant. Is that accurate? Like the fee for polluting under maybe the Title V program, for example. But you guys don't have Title V sources, I'm sorry.
Yeah, I'm not aware of that exactly, because I know what we pay per year is less than what we pay for the city, and we're paying the minimum amount for our asphalt plant for the city of $10,000 a year, even though I have not used it because I'm afraid if you don't use it, you lose it. So
Right.
I'm paying it.
Okay. Okay, I guess so my understanding now is that it's NMED's process is quicker and cheaper for you.
From our standpoint, that would be correct. Yes.
Okay.
That is based on my experience as well.
Okay. There was one last question, Mr. Caldwell, that you brought up that this idea that from your experience, the requirements don't necessarily lead to your best practices to reduce air pollution. Is there any data or any, can you point to any processes, or I understand how the requirements can be maybe duplicative or cumbersome, but I'm trying to get at why those are not reducing air quality.
Yeah, so
Pollution.
it would be more, for instance, written inside of the permit, my latest permit, you know, they want quarterly reporting of setback distances from a fence to a bag house. Once we set that piece of equipment, we really don't ever want to have to move that again, because it's incredibly expensive to move any of these facilities. It's very expensive. Then they also want you to know, they want to monitor the distance between daily, measure the distance between fences and stockpiles. They want you to monitor what was the weather like? Did you have to apply water? Why did you not have to apply water? What were your truck counts that day? What, you know, obviously, they also want to know, did you bring in, for instance, my permit, we're tied into New Mexico Gas Company. It's a hard line that goes there, but yet they want me to submit reporting that says that I'm bringing in pipeline quality natural gas. Well, I can't truck it in. I don't truck it in. I'm piped into New Mexico Gas. And so there's also several other monitoring requirements that they're just very repetitive, very duplicative. Does that answer your question?
I think it does. Thank you all. I don't have any further questions.
Can I just ask one burning question?
Go ahead.
Before you all leave, it's been really great having you here. I've learned some things. One of you mentioned, I think it was you, sir, that with Mountain States, mentioned that it would be preferable for the community, the affected community, to enter into this process earlier. Is that correct?
That would definitely help from the standpoint of being able to address the concerns, because once again, if we meet all the criteria from a standpoint of air quality, zoning, everything else, and then get derailed because of public comment for a period of time, then not only costs more money, but it takes longer to get the process done. So if we could get that earlier, that would be helpful.
So I know I have been in meetings with EHD when I was working at the county environmental health department there. And we used to go to meetings that actually covered rulemakings or proposed modifications to rulemakings, such as the one we're doing now. And it struck me that oftentimes the stakeholders that were not included were the community. So it's sort of the opposite of what you're concerned about. And I'm wondering how to kind of bring both parties to the table so that during rulemaking, there's equal input to draft a rule. And we've actually attempted to do that throughout this process. And apparently you were not notified until last year, basically a year ago. But I'm just wondering about your thoughts about that, because it always struck me when I was going to those meetings that the only people that were in the room were folks who represented industry.
Obviously, the more conversation that you can have between everybody, I think would be beneficial, obviously. And it's hard. Obviously, we don't want to go into a situation unless we are fairly certain that the approval process will take place. So we can, if I can go to Paul Wade and say, Paul, this is what we'd like to do in this area. What do you think? And he can do an analysis and say, you meet all the requirements. And therefore, I think it would be good for you to proceed. Possibly somewhere in that point in time, then a meeting could be held with the community and say, there's a preliminary approval by their engineering firm that they're using, and this is what we'd like to do, and address concerns. And the concerns can't be, in my opinion, we just don't want it. I mean, obviously that can be something, but if it's in a location that is zoned properly, then what we as an industry need to know is, what are the rules? What are we playing by? That's all we want to know, is what rules are we playing by?
Okay, and what I was referring was not necessarily the permitting process, but the development of regulations like what we're addressing today. Whether, again, when I was in meetings with EHD regarding redlining of proposed regulations, which I quite frequently was, I noticed an absence of community representation. And my question to you is, how do we facilitate it so that all parties that are affected, both the business community as well as the residential community, is in the same room to come up with a rigorous, predictable rule?
Well, the only way and I'm not an expert by any means, but a suggestion would be that all these various city coalitions that there are, that somehow there's a database that has all these people in it, or all these locations into it, that they then could be sent letters to, or notified somehow. That would be the only way I would know how to do it. I mean, what we have to do, obviously, when we're doing we have to go within a certain parameter around where we're going to be, and we have to notify all those people and let them know. So maybe they have a better idea.
The other piece of that may also be just simple business practices, right? A marketing effort, news ads, radio, television. I mean, if you want to get the communication out there and try and bring industry together and the community to establish an adequate rule, then why wouldn't the environmental health department put their sneakers on and go door to door and go to the businesses? They have the addresses of them. They understand which areas are going to be impacted. They understand which coalitions are going to be concerned about that. And yeah, I mean, that goes back into having some resource, but that would help.
Thank you so much. I'm sorry to delay lunch for you.
How are you doing? Okay. If it looks like it's going to be a long examination, we'll take a break. Mr. Mullenberger or Mr. Trujillo, I believe you're online. Are there any questions? Mr. Trujillo?
No questions.
Mr. Rose?
I'll try not to delay lunch. No questions.
Okay. Mr. Calderon or Ms. Navarrete?
No questions.
Ms. Richards?
No questions.
Mr. Harris or Mr. Poutier?
No questions, Your Honor.
City HD is not here. Is that a Pueblo?
No questions.
Captain Nafke, on behalf of you and Mr. Willard?
Nothing, sir.
Ms. Semino is online. I'm gonna, if I don't hear from her, I'll assume that she has no questions of this panel. Mr. Jantz or Ms. Luck?
No questions, Judge.
Great. So I believe there shouldn't be a need for a redirect.
Mr. Judge Sanchez?
We just have a few.
Oh, yes, I forgot about Mr. Pasiniak. Sorry.
We just have a few questions. I don't think I'll delay lunch.
I had you on my list. I just, and I hadn't checked it. All right, you're next.
Be nice.
I will be very quick. I know everyone said that. But just as an introduction, my name is Rahika Rai Caulfield. I represent some of the community interveners on behalf of the UNM Law Clinic under the supervision of attorney Gabe Pisiniak. Most of these questions are yes or no, but feel free to elaborate if you need to. Just to clarify, gentlemen, have you all read the rule as proposed? And this could be any version, 4, 5, 6.
Yes.
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 And just to clarify, you're aware that the rule as proposed doesn't apply to permit modifications that don't result in an increase in permit emissions, correct?
That is not our understanding based on our interpretation of the rule.
Okay, well, in the rule under 20.11.72.15D, it's a long acronym there, but on any of those versions, are you aware that that is what it says? Objection asked and answered. I'll move on. Mr. Wood, you specifically, could you clarify, are you concerned that under this proposed rule, you would be denied a permit application based on where your facility is located?
Well, our facility doesn't move, at least our asphalt plant. So yes.
And is that also perhaps at all because you're concerned about the levels of admissions that you currently have and its effect on the permitting process if this rule was imposed?
No, when we go for technical modifications, as I explained, to replace or upgrade a piece of equipment, that's automatically a technical modification. And so I would have to go through all of this stuff just to change out a piece of equipment.
And my final set of questions are for you, Mr. Caldwell. Just to clarify, it's correct that you testified, and this is docket 189.12 on page 2, that you've spent about the past 8 years working and obtaining air quality permits, correct?
Yes.
And you've had some questions about the cost of permitting, but I just wanted to clarify, in that time, has that cost of permitting by the Department of Environmental Health gone up at all?
Yes.
And in that time, have your costs of services and products gone up at all?
Yes.
And then one final question. Oh,
I
go
might
for
add
it.
to that. So has the cost of all the inputs under the economic circumstances that we've been in since the pandemic.
Sounds good. And one final question, Mr. Caldwell, based on your answer to Member Armijo's questions, in your answer to whether or not you were aware of any overburdened communities, you mentioned that you shut down a facility in the South Valley community. May I ask, did you shut down because of your worry? I guess I was confused with your answer to that question. Did you shut down because of your worry of your effect to overburdened communities?
That facility is an older facility, and so we shut it down to be able to set up a newer, more efficient facility in a different location. We had the opportunity to install our new equipment within that location, and we made the decision not to do that.
So it had nothing to do with the concern for the community surrounding the facility, correct?
I would not say that.
Okay, that's all I have. Thank you.
Reconsidering that the board did question this panel, Mr. Domenici, you have an opportunity for a short redirect.
This will be a lawyer type 1 question exam, hopefully. Mr. Wood, Mr. Otoski, Mr. Caldwell, are you concerned that the proposed new rule has denial criteria that you could not overcome if you needed a permit modification?
Yes.
Yes, it does.
Yes.
That's all.
Thank you for the one question.
If I could, I know we're moving on to maybe lunch, but I do have one of my experts, very short. I have two witnesses talking about the FAA requirements at the airport. I wonder if the board would indulge allowing them to, I can't imagine the whole thing would take more than a half hour.
I hear I see my chair saying, nodding yes. This panel is done, so thank you very much. You can-
Oh, yeah.
Thank you.
Thank you.
All right. Who do we have, Mr. DeBenci?
Yes, this is Mike Minicucci and Vince Martinez.
Mike Minicucci, my classmate, is to the right. Press the green button.
Sorry?
Oh,
That one?
That's it.
Okay.
Mr. Martinez, Mr. Minicucci, if you can raise your right hand, please. Do you swear to tell the truth in this proceeding?
Yes, sir.
Thank you.
I'm going to go with you first, Mike Minicucci. Introduce yourself to the board, please.
I'm Michael Menicucci. I am an attorney that limits my practice to construction issues. And I have limited my practice to construction issues for about 44 years.
Do you have an engineering or construction background?
I do not have an engineering background except for undergraduate work. I have a construction background in working as a project manager and a risk manager for a construction company for 12 years after I graduated from law school. Prior to law school, I worked exclusively in construction and engineering in the 4 years of undergraduate work and the 3 years while I was in law school. I practiced law for about 9 months in a non-construction issue once after law school. That didn't suit me well, and I went back into construction and stayed there for about 12 years before I got into private practice again.
I'm going to focus very quick, precisely on a couple of issues. So there's lots of acronyms. Describe what the federal acquisition regulations are with respect to construction projects.
The federal acquisition regulations regulate all type of construction, contracting, procurement, if you will, warranty. There's no warranty issues, but if you will, post-construction issues related to any type of construction for the federal government and agencies within the federal government, including all agencies within the Department of Defense, which has their separate set of regulations under the FAR.
So you were asked to testify regarding the requirements for your client, Vince Martinez, to do work at the airport. Can you summarize what those requirements are?
I've been asked for my experience related to concrete paving and some asphalt paving, but concrete paving related to works for airports and military institutions, including runways, taxiways, and aprons. The ASTMs for normal concrete paving on highways and intersections is different than the FAA regulations and the Department of Defense regulations for concrete paving. The nature of concrete is such that its utility is within its strength, and the particular use on runways, taxiways, and aprons require high strength concrete. In order to do that, the mixing process or the batching process and the placement is a critical issue. My experience and a lot of work I do for Vital Consulting Group is the negotiations of in the contract once the contract has been awarded for placement of the concrete plant. It is critical under FAA regulations and under military regulations, Department of Defense regulations, I'm sorry, that the concrete be placed within 45 minutes of it being batched or mixed, thus requiring since 2001, where the TSA has taken over the access to airports at all locations, the perimeter fence, we call it, that the location of the batch plant be within the fence in order to meet the regulations.
And what happens if your client obtains a contract but cannot locate the plant within the fence?
It depends. If they can't locate within the fence, the material certainly can be batched, but getting to the fence, there is a 45 minutes time between when it can be batched and when it can be placed. The type of concrete, because most concrete for airports is what they call it's a 15 inch no slump mix, which is placed from the end of a dump truck. It cannot be placed from a rotation mixer that you see on the streets. And because of that, the truck coming from off-site very far, we have what is called in the industry segregation of the materials, which means the aggregates within the materials over the long period of transportation settle to the bottom or settle out, thus affecting the tensile strength or it affects the lateral strength of the concrete, and thus it would not meet the FAA specs. And so being outside of the fence, one, gets segregation because it's being transported far, and two, may not meet the 45-minute regulation because of the TSA requirement that the truck has to be fully inspected up, down, and around for it to enter the airport property. If it's the only truck, barely, it might be a 40 minutes just in the inspection time. If it's a truck in line with other trucks that have to service the property, it's certainly longer than the 45-minute inspection time.
If the FAA cannot identify contractors that can meet those requirements, what happened to the runway?
The runway, well, you won't meet the specifications, so the load will be rejected, and you have to start over again. But there may not be a possibility of ever meeting the runway. What it prevents is maintaining runways. It prevents putting in new runways. It prevents upgrading taxiways and aprons of those nature.
Are you from Albuquerque?
Yes, sir. Long time.
Is the airport important to Albuquerque?
I think the airport is vital to Albuquerque because of it's the only connection with commerce, through the aviation and including it's just not the airport. It is also it shares with the military.
And are would the inability to meet the 45-minute requirement impact the ability of the military runways to be upgraded, maintained, and improved?
Most definitely, and that was evidenced by an incident about 4 years ago where they tried to have a plant located off-site, and the construction period, because of the delay in getting the mix to the runway for it was strictly a military contract. This one, it was a apron for loading of the nuclear weapons, and they used a offsite plant, and the contract was for about 9 months. And because of the rejection of the loads, the contract went out to almost 24 months, increasing the price by, I believe, $18 million.
I'm going to turn to you, Mr. Martinez. Thank you, Mr. Minicucci. Please introduce yourself to the board.
My name is Vincent Martinez. I'm the owner, president of Vital Consulting Group.
Are you from New Mexico?
No, I was born in Oakland, California, and lived in California for my growing up years. And my father moved us to Albuquerque in my senior year of high school.
Describe what Vital Consulting does.
Similar to what Bob and Dave, we're a contractor. We established our company in 2008 as a consulting company that was pretty much just me. And then I decided that I needed to worry about, more families. And so I had 80 employees to bring on. But basically we are a construction company, and the difference between us and Mountain States and Albuquerque Asphalt is we deal with concrete. We in fact work for Mountain States and Albuquerque Asphalt on occasion as a subcontractor, and they provide materials for us. Mountain States provides us virgin aggregates as well as black rock and some of the other local suppliers.
Are you concerned that portable plants are not exempted from this proposed rule?
Yes, I am. Our situation is quite a bit different from Mountain States and Albuquerque Asphalt. We don't actually have a home for our concrete plant. My permit currently is I have 2 concrete plants that meet the requirements that Mr. Menicucci just brought up. One of the addresses is actually inside of the airport, on the south side of the airport. That was the first place we set up the plant. And this was a location that the city of Albuquerque Aviation Department designated for us to use. So we don't even have a choice where to put our plant, so to speak. I mean, kind of. I have a second plant that when I purchased it, we put it at the Amazon distribution center on that big thing that changed our skyline on the other side of town, the west side. We put probably more concrete in that building than we put on a runway project. They asked us to come in and supply concrete without interrupting the sale of for other projects in Albuquerque. So that's the location of our other permit. So when we relocate, we have to get a new permit. Well, I guess it's not a new permit, it's a relocation permit.
In order for you to bid on work on the runways, taxiways, maintenance, do you need to have a level of confidence that you will get timely approval to relocate your plant?
We bid competitively against other contractors. We don't have currently, I don't know about other contractors, but we have to bid on projects, and they give us and we know the contract. It tells us where we're going to put the plant. It tells us where we're going to put how much time we're going to get to build this job, and when it's part of the contract with the city of Albuquerque or with, say, Kirtland Air Force Base or anybody else. And when we so prior to the bid, we don't know that we might not get this project. It could go to somebody else. And so we have to have the confidence. Our confidence would be that while we do have a plant that meets the specifications currently, and the requirements of the air board or the air quality, our current permitting system. So as soon as we get notification that we're the low bidder, I mean, if we're the low bidder, we have enough confidence, we think, that the city is going to award it to us. Sometimes it takes us 2 or 3 months to get an award. But when we get that award, I mean, once we know we have a contract, the first thing I do before we sign the contract, before we do anything, I contact Paul Wade over here to start working on a permit, because the engineers and the city, they don't give us time for permitting, they give us time for construction. So we have to go right away. And when we wait 6 months of a say an 8-month contract, that gives us 2 months to build the job after we get approval. So I mean, knowing the rules, like was mentioned before, is really, I mean, knowing them ahead of time is really good. If I don't have any confidence, like Mr. Otoski said, that we can't finish on time, that we might be in default of our contract, we won't bid the job.
If you happen to bid the job and are awarded, but you can't get the plant relocated, what consequences does that have for your company?
I think my attorney would take that over.
You would
I would be in default of my contract.
You would
and
be
my
in breach.
my bonding company would take over the job, and they would have to work something out.
Would that jeopardize the financial condition of your company?
Yes, my company is everything I have. That's my investment. Well, my investment is in my kids and grandkids, but
do you have family members work in your company?
I do. I have 4 of my 7 children work for the company, and I have a grandson that works for me part-time, but he's going to UNM trying to get into the pollution industry. That slipped, I'm sorry. That was the construction industry. He wants to be an engineer. When I got told I was in the pollution industry, not the construction industry.
What industry are you in?
I'm sorry?
What industry are you in? Construction or pollution?
I thought I was in construction, but we're a contractor. We construct things. We build everything with concrete: bridges, channels, sidewalks. That's our specialty.
This may be obvious, but I want to make sure for the record. Do you consider yourself and your family Hispanic?
Yes.
That's all I have. Thank you.
The board may have some questions. Board Member Lewis, do you have any questions?
No, thank you.
Start on this end. Vice Chair Richards,
I have no questions.
Vice Chair Member Calvin,
I have no questions. Thank you.
everybody,
I have no questions.
Mr. Armijo.
I'm going to break the cycle here. Mr. Martinez, do you believe there are overburdened communities as far as air quality in Bernalillo County?
I believe there are, yes.
Okay. And if there is a simple and clear rule for permitting, as one of I believe your witnesses stated, do you think that would be an additional burden in permitting?
I'm sorry. Would you say that again?
Okay, right now you have to get a permit in order to do what you do. And if you had an additional permitting requirement to meet overburdened communities, and it is simple and clear, do you think that would be an additional burden?
Yes, it would be. I mean, I mean, when I look at the rules that were presented, and if I'm not, and maybe I don't understand it completely, but it looks like we could be looking at two processes I mean, we have to have a public hearing for one, and then we have to have two public hearings all of a sudden. And the public hearings, I'm all for public hearings, but when I'm basically told where I'm going to set the plant, I mean, and from my information, I mean, for knowing what Paul does for us in the modeling, that modeling is specific to the site. So we could try to get as much information as we can for that site. But if we're being told by the city or the other owner out there, Kirtland Air Force Base, where we set our plant, and then going through that hearing process and everything else, I mean, I think we need to streamline that somehow, get back to the one, if it's going to have to be one hearing. And the hearings, I mean, like I said, I think they're an important part. We did a hearing for one of our projects for a taxiway out at the airport. We invited the community, the air quality bureau. Well, that was when Chris Albrecht was in charge of the aviation department part of it. He got moved over to he's the deputy now. But anyway, he's been a very helpful. I mean, for us, he's a good asset for us, I believe. But anyway, he set up the meetings, and we had meetings, and we had to wait a month for that meeting to take place. There was no, and we can't set up our plant until we get an approved permit. So during that meeting, we had two people show up from the community at the airport, and one person from the East Mountain, I think, Association, Coalition, whatever it, or Mountain View. I'm sorry, not East Mountain, Mountain View Coalition. So, but anyway, he showed up and asked two questions, and basically it was, where's the press? And what does Trump have to do with this? So that was the extent of the air quality meeting that was set up.
All right. And I don't want to put words in your mouth, but I'm trying to figure out, are you asking us to reject any proposal for overburdened communities? Or are you just saying it needs to be tweaked?
I think it needs to be tweaked. I don't think, I think, I don't really understand. I mean, the overburdened community to me is that the city's set up zoning and pushed us all into the South Valley. Right. To do everything. I mean,
I guess that's what we're trying to address.
To get a permit, right. And so add to that I-25, I-40, add to that, I mean, there's a lot of different organizations that I read the papers too, and I see they talk about body shops and dry cleaners, and I don't know how many, I guess I could look it up, but I've never looked into how many permits air quality handles. But I believe that area might have overburden. I mean, I think half of my employees all live in the South Valley.
All right, thank you. And I'd like to say hi to Mr. Menicucci, fellow law student. I'm done.
Member Galuski,
Thanks for coming out. I appreciate the testimony, but I have no questions.
Chair Paul.
Only one question. Thank you both. Counsel for you. Are you saying that to meet federal requirements for runway concrete, portable sources need to be located near the runway or on site?
Yes, 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 ma'am.
Is the location of the portable source the only federal requirement that you are concerned with in the proposed regulation?
To clarify, there's not a requirement for location of the plant on site. There is a logistics issue with the timing of the completed product and placement. And so that then becomes a location issue. And so I'm saying I can't tell you that there is a requirement in the federal FAA specifications or the Department of Defense specifications for its location. There is just a requirement for its time of placement.
Thank you, and thank you for clarifying.
I need to add to that because in the Department of Defense, the newest stuff that's just been coming up in the last year and a half, 2 years, they actually have told us that we have to be located on the facility. The concrete plant has to be located on the facilities. They have it in the specifications, and those specifications, and mostly because on a federal facility, it's not just TSA now, we're talking about the Department of Defense. So they require the plant to be inside of the facility.
Let me clarify that one bit. Up until 2 years ago, each branch of the Department of Defense had its own specifications. 2 years ago, and their specifications varied. Not as to strength, but they varied as to other deals. 2 years ago, that is being consolidated now into a uniform Department of Defense specifications, which will have, when adopted, the requirement for the plant to be placed on site, mostly for nuclear regulatory agencies.
Thank you. Bear with us while I go down the list. Hopefully there's no questions, but Mr. Trujillo or Mr. Mullenberg?
No questions. This is Mr. Trujillo.
Okay, I can see that on the screen. Mr. Rose?
No questions.
Mr. Calderon or Ms. Navarrete?
No questions.
Ms. Richards?
No questions.
Mr. Harris or Mr. Boussier?
No questions.
City EHD is not here. Isleta Pueblo?
No questions.
Captain Nofke on behalf of Air Force and Kirtland?
No questions, sir.
Ms. Semino is online. If I don't see a hand raised, I'm going to assume that she has no questions. Mr. Jantz or Ms. Locke?
No questions.
Mr. Paseniak?
No questions.
And because there was questions from the board, I'll allow a brief redirect.
Again, I hope this is one question. So with respect to the questions that member Armijo had, excuse me, if I understand correctly, what you are asking is with respect to portable sources that they be included in the exemption language of the other items that are actually exempt from this proposed regulation or something that might come out.
That's correct, yes.
Thank you.
Thank you, Mr. Minicucci. It's good to see you.
Good to see you.
Mr. Minicucci and I graduated from law school a little more than 43 and a half years ago. So you are done. Thank you. Thank you very much. We will take a break unless there's any announcements before we break. 45 minutes, so we'll try to get back here at 1:15.
She said